Well, good morning, everyone. It's now 10 o'clock. The inquiry is now open. Before I go any further, can everyone hear me? People hear me at the back? Thank you. Okay, my name is Stephen Normington. I'm a chartered town planner and a chartered surveyor. I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Vulps Limited, trading at Vulps Land, and I hope I pronounced that right, but I'm sure I'll be corrected during the course of the next few days if I haven't. Ashfield Land Developments Limited and Davidson Developments Limited. The application is for outline planning permission with access not reserved for up to 700 residential dwellings, areas of public open space, a rugby pitch, landscaping, allotments, sustainable drainage and associated infrastructure. And the application is accompanied by an environmental statement. The appeal site is located at land to the west of Brackley. The appeal has been made following the failure of the West Northamptonshire Council to determine the plan application within the prescribed time period. My role is to carefully consider the evidence provided in this inquiry and to make a decision whether the appeal should be allowed or dismissed. Before we go any further, can I just ask the council, please, to explain if there are any fire alarm tests today and the emergency evacuation procedures if there is a fire alarm?
Okay, yeah, thank you, sir. So there's no planned fire drills today, or I believe at any point this week. In the event that the fire alarm does sound, if people make their way down the staircase, which is just outside the room here, and then make your way out of the building and across to the mound, which is behind me.
Can I also ask to advise persons the location of toilet facilities and also explain the use of the microphone system to everybody who's sitting around these tables?
Yes, thank you. So the toilets are out of the door there, across the landing and through the next set of doors, and you'll find those. There's also an accessible toilet out through the door here in the corridor just behind. And with regard to the microphones, there's a button on the front of the console. If you press that, the red light comes on, and you need to make sure that you speak sort of directly, fairly close to the microphone for it to pick up, particularly for the live streaming on YouTube. Thank you.
Thank you, Mr. Callis. I've just one more thing that I'll come on to later, not now. It's only about access to documents, but I'll come back onto that. So thank you for that. To avoid any unnecessary interruptions, can I please remind everyone to ensure that mobile phones, email notification and alerts, and the like are silenced as far as possible when the inquiry is in session. That would be appreciated. Whilst the overall inquiry will be undertaken face-to-face in this room, the closing submissions, which are scheduled on Friday morning, will proceed by virtual means. All proceedings will be live streamed. In a moment, I will explain the arrangements for those persons who wish to speak today. Firstly, though, I do need to run through some housekeeping and some organisational matters that are specifically related to this inquiry. Firstly, in addition to live streaming, does anybody intend to film or record the event? That's fine. I have no objections to this, provided it doesn't cause any problems in terms of being disruptive. I have produced an inquiry programme that should be available on the Council's inquiry web pages. The inquiry will proceed largely on the basis of that programme, which I'll explain shortly. If any minor changes are necessary as we proceed, I will try to explain these as housekeeping matters during the opening of the morning and the afternoon sessions. And we'll try to ensure that the inquiry web pages contains the latest version of the inquiry programme at all time. I'm not anticipating any significant changes to that programme, if I'm being honest. I'm aware that the Council's appeal notification letters and notices outline how the inquiry documents can be accessed. But before we go any further, for anyone who's not aware of the procedures how to access electronic copies of the core documents and inquiry documents, can I please ask the Council to explain how these documents can be accessed on the Council's website?
Yeah, thank you, sir. So for those who are in the room, there are actually a couple of posters on the doors, I think, which have QR codes, which will enable you to access the core documents direct from your phone. For anyone else, or to look at them on a computer, you would go to the Council's website and then go to the section where the planning pages, and then the section where you view or comment on a planning application. and you would need to type in the application reference number, which can be provided to anyone if needed, and that takes you through to the results screen, and on there you need to click on, there's 3 tabs. There's one for the application, one for the appeal, and that contains all the appeal documents. And then there's a third, I can't remember off the top of my head what that one was, but if you click on the appeal tab, that takes you into the full list of the core documents.
Just one final question, just in terms of the access to the council's internet in this room, I understand it's WNC public, is that correct?
That is correct, yes.
And I understand, I think there's a copy of the QR code on the door as people come into the chamber. So if you scan the QR code, it should take you automatically to the core documents list should you wish to see it.
Yes.
Thank you for that. The programme does provide for interested persons to speak this morning from around 12 o'clock to about 1 o'clock. I'll come back onto that in a few moments. Throughout the inquiry, I will guide proceedings, inviting particular people to speak at particular times. In general, you should not speak unless you're invited to do so. You're all expected to observe the usual courtesies and the formalities in respect of a public inquiry. If I consider the behaviour of a party is not appropriate for some reason, they will be warned with the ultimate sanction, if deemed necessary, of being able to exclude them from the event. Any action would only proceed if formal warnings were not previously heeded. I've never had to do that, but it's something I have to say. It's just a reminder that we've got a certain degree of formality. It's not a public meeting. It differs markedly from a public meeting. So we are in a structured forum today, quasi-judicial forum. So it's just me reminding persons just to be recognizant of the formality that's attached to a public inquiry. Just something for advocates that I'm required to say, but I'm teaching you to suck eggs. You're reminded in this regard that once an examination of a witness has started, they are not permitted to communicate or discuss any evidence with their own advocate, for example, off camera or during breaks, until their re-examination has been completed. I'm teaching you to suck eggs there, but it's something I just need to say. In a moment, I will ask the advocates for the main parties to introduce themselves and the names of their respective witnesses to the inquiry. The council has adopted a neutral stance in this inquiry, but will be participating in the roundtable sessions relating to housing land supply, planning conditions and planning obligations, and will be providing some planning evidence. The council's advocate will likely explain the position of the council in opening submissions. So moving on to appearances. If we could start with the appellant, please. Could Mr. White please introduce yourself and your witnesses to the inquiry?
Yes, thank you, sir. Good morning. My name, as you've identified, is Sasha White, Sasha with an S, White as in the colour. I'm of King's Counsel, and I am leading in this matter Miss Kimberly Zier, who is sitting to my immediate left. It is then my intention on behalf of the appellants to call 2 witnesses. Firstly, Mr. Neil Tiley, who will participate in the roundtable programme for tomorrow and give evidence on housing land supply. He isn't currently here, but he will be here later. And then Miss Butterfield is going to give the planning evidence to the appellants, and she is sitting to Miss Sears' left. We also might this afternoon, we will have present our instructing solicitor, Mr. Marco Mario, and he might participate, he might not, dependent on how the conversation goes. But just to notify you, there is the solicitor present from the appellants. And as I say, we don't expect him to participate, but if you have particular questions on drafting, then he is here and able to answer those. Not just drafting, of course, content as well.
Yes, thank you, Mr. White. What I will do is probably ask the instructing solicitors from both parties just to take us through some key sections of that plan obligation.
Well, absolutely, we expected that. So
yeah. So if I'm being honest, I haven't got many questions on that obligation. But I think it's important that we just go through step by step just to check for interested parties that we understand what the content's all about. Thank you for that, Mr. White. Mr. Fraser Urquhart, could you please introduce yourself and your witnesses to the inquiry?
Yes, sir. Good morning. My name is Andrew Fraser Urquhart. That's Fraser with an S, and then it's Urquhart. I am also of King's Counsel. I will be calling two formal witnesses, Mr. Dan Callis, who will deal with the planning evidence, and then Mr. Richard Wood, who's provided a proof of evidence, but will contribute through the round table session on housing land supply matters. At that stage of the inquiry, Mr. Wood will be assisted by Mr. Alan Munn, who will simply confine himself to providing information on particular sites. And then in like manner, as the appellants for the purposes of the roundtable session on the obligation this afternoon, Ms. Sian Webb, who is the council's principal planning solicitor, will be in attendance to assist.
Thank you very much. Thank you. Just turning now then to interested parties who wish to speak to the inquiry. As mentioned earlier, the inquiry programme provides a slot later this morning, starting around about 12 o'clock, it might be earlier, and go on until about 1 o'clock, or might be a little bit later than that, but I think we'll get through most people in that slot who may wish to speak, both in objection and in support to the development. So I have already a number of interested parties who have registered to speak. I will go through them now, and the order that I read the names will be the order that I will ask persons to speak. So the planning inspector has been notified of a number of people. Firstly, Councillor Fiona Baker, who was a ward councillor for Brackley. Then I have Mike Graves and John Brooks on behalf of the Brackley Angling Club. I have Alan Mays from... Sorry, I will. Councillor Fiona Baker, ward councillor. You need to write quicker, Mr. Fraser. I'm only kidding. I can send you these if you wish to know them, but I'll go through them again when I call people. Mike Graves, Graves, and John Brooks on behalf of the Brackley Angling Club. Alan Mays, that's Mayes, on behalf of CPRE. And Kevin Blencow, which is Blencowe, who's a resident. And I think Mr. Blencow is speaking in support of the principle of the development, as opposed to being in opposition. In a moment, I will ask if there's anyone else whose name I've not just read out who would like to speak, and who knows at this stage that they do certainly want to speak. Just for those who are speaking and those who might wish to speak, you should know that if you do speak or ask any questions, that I'll come on to that in a moment in the inquiry, your name will be listed in my decision. Before I do take names of any other people who wish to speak, just need to point out that I do have access to copies of all the representations submitted in this appeal. Therefore, it's not wholly necessary for you to speak on comments that I have already read. We do have a lot of technical evidence to go through, particularly tomorrow, and it's not helpful for parties to repeat matters that I've already either read or have already been said by other people. So just be mindful of that if we can. Having said all of that, I don't wish to deny anybody the right to speak should they so wish to, particularly if there's something that you might wish to say that I've not read. That's really helpful to me. So just bear that in mind. If you can think about repetition, think about what you've already said. You can direct me to that, but sometimes repetition is not helpful. So just be mindful of that. For those people who do wish to speak, you'll be invited to the witness table, which is a table directly in front of me, to present your views. Just before you do start to speak, I will ask you a couple of questions, just so you're aware of it. I'll be asking you whether you represent anyone or any group, whether you support or object to the proposed development. I will also ask you, particularly those in objection to the scheme, if you are content for the appellant's advocate, Mr. White, to ask any questions on what you've said. You don't have to ask questions if you don't wish to do so, but if you don't answer questions, that may reduce the weight that I attach to your evidence if you're unable to respond to questions that are raised. So I will ask you that for each witness each time you come sit at the witness table. For those persons who've not pre-registered, i.e. if I've not read your name out, and are present in the room today, if you do intend to speak, could you please raise your hand now and I'll take your details. So other than the 4 people that I raised or the 5 people that I read out, is there anyone else who wishes to speak today whose name's not been previously sent into the Planning Inspectorate? Thank you very much. There's no other people other than the ones on the list. Just for people who are observing inquiry today, I recognise that you may be unfamiliar with some of the proceedings of an inquiry. Where I think it's necessary, I will try to explain the reasons for the order of events over the next few days. And where those who have expressed a desire to speak and do speak, where those persons will be offered an opportunity to cross-examine the appellant's witness for those in objection to the application, or for those supporting the application, the council's witness. I'll let you know when you can do that as we go through the next few days. Just one final matter regarding people who do speak later this morning. If you have prepared a speaking note that you're reading from or addressing, it would be helpful if you could send a copy of that to the Planning Inspectorate case officer. You've all notified him already, so you know his name. It's Tim Salter. Or give a copy to the council's officers today, or a hard copy to me when you're speaking, and I'll record that as an inquiry document. You don't have to do it. It's just helpful sometimes to have the formal record of what you've said, formally record on the council's inquiry website. And I will refer to that then as an inquiry document in my decision. I will still make notes of what you say anyway, but it's just a little bit help in terms of ensuring we've got a copy of what you've said. Just on notification letters, I've seen a copy of the council's notifications around announcing the arrangements of the inquiry and a list of those to whom it was sent. I've also seen the copies of the representation submitted to the council in response to the plan application. And I mentioned earlier, I've also got copies of those submitted to the Planning Inspectorate as part of this appeal. And I will be taking into account all representations and coming to my decision. Just on to plans. There are several relevant plans which I refer to in the draft conditions. I'm not going to go through those at this stage. But in advance of discussion this afternoon, can I just ask the council and the appellant just to double check we've got the right plan numbers, right drawing numbers, right revision numbers, just so they're up to date. I'm sure they are, but it's important that we ensure that we've properly referenced the right plans. I've been caught out by that once before, and so I reinforce that sometimes where we have a revision A that's in the conditions, and actually the plan we're looking at is a revision B. So it's just to be sure that we've got the right plans.
Based only once before, sir.
Well, I would be kind, if I'm being honest. But it is important that we get those plan numbers right. I have checked them against what's in proofs of evidence and lots of other things. And I think we're all right, but it's worth you having another check because you know what's right and what's wrong. I can only assume what's right and what's wrong from what I've read, but let's just check that for this afternoon. Just on conditions and plan obligations, as I mentioned earlier, we're going to discuss this afternoon the conditions that are recommended to be imposed on the application were I to allow this appeal. For those that's not familiar with that process, this is normal practice, and it's not to be taken as a meaning that I've made my mind up regarding my decision on this appeal. It's just something we have to do. We are required to go through planning conditions during the inquiry. It does not weaken the objection raised by interested parties in doing that. Neither does it strengthen the appellant's case that planning permission should be granted by the appeal being allowed. Rather, in the event that I decide that the appeal should be allowed, any conditions imposed do need to have the benefit of discussions in this room. A list of suggested conditions has been produced, which I think should be available on the inquiry website, and I'll be using that this afternoon to inform the discussion. So when we go through planning conditions, I'm just going to go through that list sequentially. Quite a few I don't have comments on. There are a couple I do have some comments on, and a couple that I'm sure I don't think they meet the test of a condition. But I'll come on to that this afternoon. I also have a draft plan obligation, which seeks to secure, amongst other things, contributions and other measures aimed at mitigating the impact of the development proposed. We'll also discuss this afternoon that plan obligation and its content. And now I have the SIL compliance statement. I had it all along, but I couldn't find it in the inspectorate's filing system. But I have that now, so thank you for that. Just in terms of the inquiry timetable and arrangements, the inquiry is currently programmed to sit for 4 days. That's Tuesday to Friday this week. Other than today, the inquiry will resume at 9:30 on Wednesday, Thursday and Friday, and will adjourn around about 5 o'clock each day. It might be a little bit early, it might be a bit later. Each day we are sitting, we will have mid-morning and mid-afternoon breaks, around about 10 to 15 minutes. That will be somewhere at an appropriate time. We don't give times for those breaks. It's just where the proceedings fit best for a break. There'll also be a lunch break today of around about 45 minutes to 1 hour. But I will announce all those breaks, the time we need to be back in the room as we proceed through the next few days. In all the evidence that we need to within that time, we'll need the cooperation of all parties. To that end, I'm teaching advocates to suck eggs and witnesses too, probably, but I'll remind you, it would assist greatly if questions put by advocates and others are clear and focused. And also if the witnesses could respond directly to each question put to them in a focused manner as possible, stating with a yes or no, where it's that type of question, and then if necessary, going on to qualify the answer. It's just a reminder that some witnesses do try to avoid answering the question and answer a question that's not being asked. I'm sure you're not going to do that. And there only becomes so much time that you can keep asking the same question before I lose my patience as well. So I'm sure that's not going to be the case, but just be mindful of being, well, you're reminded of your code of conduct anyway as professional witnesses in responding truthfully to the answers that are asked, the questions that are asked. I always have to say this, but I never do it. Any adjournments, I try to leave the room first to avoid being left potentially with one party or the other. That's now impossible, but sometimes I will try to get out of the room first. If not, I try not to speak about inquiry issues to either party, or I'm still left in the room. Inquiry time sessions are limited. So when I give a time to resume proceedings, I use my computer clock, which will be the same as mobile phone clocks, not the clock on the wall. So if I say a certain time, I mean a certain time, I'm not waiting for people, I will start without you. So if I say 2 o'clock, it's 2 o'clock. It's not 1 minute past 2, it's 2 o'clock. And that's important for people who's observing as well through the live stream. Moving on to procedures and the conduct of the inquiry. I'll be following the 2000 Inquiry Procedures Rules. I'm only going to say this once. That's the Town and Country Planning Appeals, brackets, determination by inspectors, close brackets, open brackets, inquiry procedure, close brackets, open brackets, England, close bracket, Rules 2000. I'm not going to say that ever again over the next few days. But there are certain procedures that's in legislation that we have to follow, and that are those procedures set out in that legislation. When I've concluded my opening remarks, I will invite the appellant and the counsel to each make a brief opening statement, which should be no longer than around about 30 minutes. This will help everyone understand the main arguments and the counsel's position in this appeal. I have asked for copies of each party's opening statement. Those have already been submitted to Tim Salter. I've received them both from the counsel and the appellant today. I'll give those inquiry numbers in a second. You can give me hard copies if you have them. Those are often quite welcomed. But if not, I'll open up the electronic copies. Those opening statements should take us around about, I hope around about 11:45, so we can have a break. Then at 12 o'clock, we'll hear from interested parties. I'll go through that speaking order again so you know where you are going to be invited to the witness table. As I mentioned earlier, the inquiry will proceed as a combination of roundtable discussions. That'll be where we have a chat that I will lead those discussions, almost as similar to a meeting, but a little bit more relaxed. And then it will also proceed on the basis of some formal evidence where there will be formal witnesses sat at the witness table, which will be cross-examined by respective advocates. The roundtable sessions I mentioned, we'll invite interested parties who've spoken today to participate in those roundtable sessions if you do wish to do so. You don't have to do, but I will invite you to come and sit. I'll move some of these people out. If people do want to participate in discussions for a roundtable session this afternoon on the planning conditions and obligation, and a roundtable session tomorrow morning on housing land supply, you're quite welcome to do so. So I'll invite you to do that. You don't have to do, but if you want to do, you're quite welcome, and I'll make arrangements that you join us for those discussions. So in terms of what the rest of the week's going to pan out like, you think you know now what's going to happen this afternoon. Tomorrow morning, there'll be a similar roundtable discussion on housing land supply. In the afternoon tomorrow, we'll start to hear formal planning evidence. So we'll have first of all have Mr. Callis on behalf of the council. That will take us to the close tomorrow afternoon. Thursday morning, we'll commence with evidence on planning matters from Sarah Butterfield on behalf of the appellant. The afternoon on Thursday will be an accompanied site visit, commencing around about 1 o'clock, 1:30 on site. I'll come on to arrangements for that in a moment. That will take us to Friday morning, and Friday morning will be the close of submissions on behalf of the council and then the appellant. Those will commence at 9:30 and they will be undertaken by virtual means. Can I ask the council to confirm that the invites, whether it's through Teams or whatever channel it is, are already being sorted for those?
So there is actually a slight wrinkle in the situation on that. I know from past experience that the inspectorate tends to use the Teams platform. Unfortunately for this authority, if we are to live stream it, that will need to be on the Zoom platform. Now that causes no practical difficulties in terms of presenting the material, but if there are protocols in PINs that need to be observed, then some different arrangement will need to be found. It may be that PINs can host that session, which I think then automatically enables people to join. But we don't know whether that will how that will sit with the live streaming.
Okay, I'll probably have a chat offline about that then through Tim. But one of the things we might need to do is have a dummy run in terms of a dummy Teams, a dummy invite, so that I can see if I can get on there. If I can get on there, then there's not an issue for Friday. If I can't, it's something in our system that's blocking it. And then we'll need to do just something through Tim. So what I would suggest then, it might be helpful this afternoon if you could set up a dummy. Probably when we've closed proceedings today, if you can just set up a dummy invite, and I'll see if I can log on to that dummy invite and see if the system in PINs will let me onto that. If it does, then we should be all right for Friday. If not, we'll need to do something back at PINs in terms of sorting out how we can do that.
Sorry, can I just clarify? So is that just a dummy invite for yourself?
Yeah.
Not for...
Yeah, because I'm assuming that Mr. White and yourselves are going to be, you're going to be okay. I'm governed by various protocols of data security that are government linked. And I don't think in our apps we have Zoom. We used to have Zoom, but I don't think we have it now because we moved all onto Teams. But we'll try, and if not, then we'll need to make some arrangements with Tim for Tim to send out Teams invites and see if we can do it that way. So you might have to have a dual system somewhere.
No, we can certainly arrange that dummy meeting for you.
All right, so once we've finished today and I've adjourned, we're not going to discuss evidence. All I'm going to do is just see if I can get onto the Zoom call. And if I can do that, then we should be all right. But I'll equally let Tim know that this is what we're doing. just in case. All right,
Yeah, no, yeah, we'll sort that out and confirm in the break, sir.
okay. No, I'm just thinking about that, actually. That's not going to be as easy as what I just said. I know I'm departing from my speech. I don't want to get bogged down with that. You'll probably need to do that through Tim, because you can't send it to Tim and Tim's going to send it to me because you can't send it to me direct. So, so you need to do that. All right. Right, so Friday morning will be in some electronic format, virtual closings. First of all, the council, followed by the appellant. These will commence at 9:30. Copies of the closing submissions will need to be sent to Tim, which you've already done this morning for the openings, before the commencement, so there's sufficient time for me to read them before we commence. It's important to bear in mind that closing submissions will form the summary of each of your cases and must therefore be fully referenced, ideally with footnotes highlighting where the references or evidence relied on can be found. I don't need to say that. Appropriate time. I mentioned earlier that interested parties who speak today will be invited to ask questions of the witnesses. I'll let you know when you can do that, should you so wish. When you do that, though, it's just a reminder that that's not an opportunity to restate your case. It's not an opportunity to ask questions that's already been asked by advocates. And it's not an opportunity to introduce further evidence. It's simply an opportunity to ask questions about the evidence the witness has presented to the inquiry. So those people who might wish to ask a question, which I will let you know when, just be mindful if you start to introduce new things, that's not something that the witness has addressed, then I'll have to shut that down because we're purely dealing with evidence of that respective witness. Just a reminder to the advocates, I'm sure you do it anyway, in the form prior to the formal presentation of evidence in chief, if you can just give me prior notification of the documents that you'll be taking the witness to, so I can start to open those up and have those at hand. So it saves a little bit of time in waiting for me trying to find where you're taking the witness to. Just in terms of costs, I will need to hear any application for award of costs before the close of the inquiry. Any discussion regarding an application for costs will be the very last part of the inquiry programme. As such, any application should be made in writing, giving sufficient time for the other parties to prepare any necessary rebuttal, which should also be made available in writing. We do say we'd like to see that before the close of the inquiry. That never happens for obvious reasons because things change during the course of the inquiry. But it's just a reminder that the last part of the inquiry will be a discussion about costs. If there are any applications, that's the point. We will hear them, and then I will set out some appropriate timetable arrangements after the close of the oral sessions of the inquiry for responses to be made, if that transpires to be the case. Whether or not a cost application is made, just remind parties that I have the power to initiate an award of costs, whether or not any applications are being made by any party. If I were to do this, it would follow a written process with the relevant party after the appeal decision is issued. I've never had to do that, but I'm aware of some inspectors who have. I won't say any further on that one. Once we've done the closing submissions, our discussion about costs, I will then close the inquiry to any further oral submissions. It may well be at that point further information may be requested by me from the parties, in particular the final version of the section 106, the signed version. We'll have a discussion about what's an appropriate time for that to be submitted. Once that's come in and anything else that I've requested, I'll then close the inquiry formally in writing. But from Friday afternoon, hopefully, there'll be no further submissions other than matters that I have asked for during the course of the inquiry, or sometimes for the Section 106 agreement to be completed and signed. So I won't accept any further submissions and nor will pins other than those that I've specifically requested. So once I close on Friday lunchtime to oral submissions, if people do think they want to get something off the chest and write in, the pins case officer won't entertain it, it'll be returned. Just on the site visit, I've already had a quick look at the site. I'm aware of its general surroundings. For the formal site visit on Thursday, I have a detailed itinerary. I assume there's been no changes to that. Seems pretty straightforward. If that itinerary is not on the website, can you please ensure that it is? I don't think it is, but it might be worth just putting that on the website. Just on the site visit, in theory, anybody can attend that site visit from the community, but we do need to be sensible and keep numbers to manageable levels to ensure that we see what we need to see. In this regard, from the main parties, I'm looking for a maximum of 2 representatives from the appellant and the council. But I suspect, given the nature of this appeal, you can probably do with 1 each, to be honest. It's entirely up to you, but if we can just think to be manageable, a maximum of 2, a minimum of 1. If it's 1, it's fine. Interested parties can attend that site visit also, if you so wish to do so. And I will just take the names of anybody who wants to accompany us on that site visit on Thursday, so we know who we can expect to see. There is a meeting point. There's a couple of meeting points on that itinerary where we will be parking for convenient walking routes into the site. I think there's about 3, might be wrong, but I think there's about 3. You'll see those on the itinerary. But if you do wish to attend that site visit, you're quite welcome to do so. Again, just think about manageable numbers from the community. There's one site visit where I had 3,000 people. I'm not going to say where. I'm not expecting 3,000 people, but just be sensible about numbers. But please join us if you want to do so. The site visit is not about hearing any further evidence. It's just pointing out features that you think that I need to see. So it's not to discuss any aspects of respective cases. It's not a forum for lobbying community concerns or any aspects of the case. But you can point out to me things that you need to be aware of that, or that is this. This is what this looks like from this particular angle. Various features that you can point out on the site visit if you do wish to accompany us. All right. I'm sure you'll allow me the opportunity to conduct that site visit without any obstruction for the purpose that it's intended to do so that I can see what I need to see. Nearly completed now. Just in terms of the main issues, having reviewed the evidence, and it's not really changed since my case management conference, I think the main issue in this appeal is whether the proposed development would comply with the development plan and whether there are any other material considerations to justify a decision other than in accordance with the development plan. And consideration will also be given to the need for the proposed development in the context of the Council's housing land supply position. In addition, consideration will need to be given to any environmental, social, or economic benefits that need to be weighed in the overall planning the overall planning balance, and that includes disbenefits as well as benefits, including implications of not proceeding with the scheme. There are lots of other matters that's been raised by interested parties in written submissions so far. Whether any of those are matters I will deal with as main issues in my eventual decision will depend whether or not, in the light of evidence submitted to and heard in the inquiry, in due course, that those matters are determinative in relation to the outcome of my decision to allow or dismiss the appeal. So what I was really saying there is that there are a couple of structural issues that I think are the main issues between the council and the appellant, although the council adopted a neutral stance. But I'm aware that those don't encompass some of the things that interested parties have raised. So it's me saying that I will be taking all of those matters into account. If there's something that I think needs to be given a little bit of prominence as a main issue, then I'll make that decision as I further read things and hear things and see things over the next few days. Environmental impact assessment. The plan application was accompanied by environmental impact assessment. As part of the appeal procedures, the adequacy of that assessment has been considered by the Planning Inspectorate's Environmental Services team and found to be adequate for the purpose of compliance with the Town and Country Planning Environmental Impact Assessment Regulations 2017 as amended. Just want to say something towards the end now about conducting expectations of a public inquiry. I think I mentioned this earlier. We've got a certain degree of formality today. It will follow a structured approach. You're going to hear things today and tomorrow, probably on Thursday and Friday, of things that you don't agree with. But you'll need to be patient listeners and refrain from interruptions or other expressions of support or disagreement in any form, allowing those who are speaking on those matters the opportunity to do so without fear or favour. So you will hear things that you think that's not right. I disagree with that, but you'll need to keep your powder dry, I'm afraid, and let those people say what they wish to say. When we do start to hear from witnesses, I will not permit any interruptions or questions from any interested parties during the formal presentation of evidence by a witness. But as mentioned earlier, I will permit some questioning for those from those interested persons who've spoken at the inquiry at an appropriate time, and that's usually after the completion of cross-examination of that particular witness. But say it's not about asking things that you've already heard or making further comments. That concludes my open remarks. Just a final reminder that to remind persons who are speaking during the course of the next few days to use a microphone system. Are there any other questions that anybody wants to raise or unsure about procedural matters or housekeeping matters that I need to be aware of? That sounded a lot what I've said this morning. It'll become very apparent the way the inquiry progresses over the next few days. How it has a little bit of a structured approach. And I'll try to explain why we're doing certain things at certain times. And it does sound a little bit of a formality, what we've just been through there in terms of being fairly rigid in its approach, but hopefully we'll ensure that people who want to participate can participate during the next few days. That's concluded my opening remarks. I think we'll then start with opening submissions now. We'll start with the appellant and followed by the council. Mr. White, I have an electronic copy of your submissions, which I'm going to record as inquiry document 1. And Mr. Fraser, I've got yours too, which I'm going to record as inquiry document 2. So in 1 is the opening submissions of the appellant, ID 2 is the opening submissions of the council. So if you can ensure that those are on the website appropriately. And if we do have hard copies, that greatly assists me as well. Thank you, Ms. White. Just be careful of the cables. Tyler, when you're ready, Mr. White.
Thank you, sir, and I will identify that as ID 1. Sir, just to deal with the geography of the opening submissions, the vast majority is written text. At the very back, I have 2 appendices. The first is a chronology of events that hopefully shouldn't be too contentious, but is to assist you. And I give the CD references where you can find those events, like obviously I think of relevance is the creation of the Joint Planning Unit back in the distant past in 2008, the publication of the various MPPFs, then the core strategy in December 14, the Minerals and Waste Local Plan, which obviously it is agreed between the parties that there are no relevant policies, so that won't take our time any further. We then had the Part 2 South Northamptonshire Plan adopted. Then the fundamental issue was the creation of this council, now the LPA, with the merger of the 3 authorities. Soon thereafter was the application on the 20th of April 2021, this application. Then its various it was obviously subject to various amendments, considerations, and I think then we critically come to the middle of 25, where the LPA published their HLS assessment, which will obviously take up a lot of time tomorrow, and the appeal was submitted for non-determination on the 3rd of June. National Highways reconfirmed no objection. The start letter was the 24th of June, and then critically, the LPA took this matter to committee with the putative consideration of what they would do and resolve the first reason of refusal, which hopefully you'll hear this afternoon has largely been met. We then deal with the matters that led to this inquiry in the commencement today on the 28th of October. My understanding, and forgive the question mark, and my learned friend or Mr. Callis can confirm, or Mr. Wood, that there is a further Regulation 18 consultation on the emerging plan, which commenced in October 25. So that's Appendix 1. Appendix 2 has sought to identify the relevant policies of the development plan, and what I've done, this is largely taken from the Statement of Common Ground, and you'll see that we've got two documents, the core strategy and the local plan. I've identified the page that you can find those. That is the written page in the document. So when you open your PDF, it will be the written page in the document. In bold are those that Mr. Callis, I apologise for misspelling his name in the heading there. I'm sure he'll forgive me, and I won't be the first to walk down that route. But being called Sasha, it happens to me on a daily basis. But it wasn't intentional, I assure Mr. Callis. It wasn't act of gratuitous violence, just a mistake on my part. But the policies in bold are those that Mr. Callis says in his proof are the key policies. You then have LPA position on breach and weight, and I think you probably picked up the key breaches that the council and frankly the appellants accept, and the weight to be given to the policies in both the local plan and the core strategy. So I just hope that's a useful kind of aid memoir on the development plan. Unlike a lot of cases, it's not critical because I think, again, like much of this appeal, there is agreement between both the LPA and the appellant that the development plan overall is breached. But there is obviously the question of how that fits into weighting of those breaches in the overall Section 38(6) exercise. So I hope that exercise is helpful for you. It should be factual. If Mr. Callis or my learned friend think in any way that the LPA position is not accurately represented, then of course it must be subject to amendment because it must be accurate for you. But it was just an attempt to assist you. So that was the purpose. So if I could go back to the text at the beginning, as I've identified, and just for your benefit, for when you write the decision letter, we set out the formal qualifications of the two witnesses for the purposes of your report, and we set out what you should have received. So if I could start with the introduction, and of course, as you've kind of implied, sir, this is an unusual appeal in which ultimately the two main parties agree that planning permission should be granted for the proposed development, and that is set out in the main Statement of Common Ground. And we say that agreement is eminently sensible in the following circumstances which make the case for granting permission overwhelming. Of course, the context in which we sit here in October 25 is a national housing crisis in the UK, and no one can deny that it's in the grip of such a crisis. Nationally, there is a need not to provide 50,000 houses per annum, not 150,000 houses per annum, but the government's position now is 370,000 homes per annum in order to meet the government's milestone of delivering 1.5 million new homes in 5 years, which was set out in that news review that I identify at the bottom. The target is not an academic figure, but it reflects very real situations faced by very real people. There are 1.3 million households on social housing waiting lists, and a record number of households, including 160,000 children, apparently living in temporary accommodation. Most importantly, the current likelihood of meeting that requirement is small in view of the inevitable problems of getting permission for housing developments. And frankly, all hands need to be on the tiller to achieve that requirement. I'm slightly cautious about using any such phrase in case it's not permissible, but I think that's probably reasonably neutral. And I hopefully wouldn't offend too many people, but all hands need to be on the tiller. There is a clear local need for housing, as Mr. Tiley will details in his proof, and you'll hear tomorrow. We say there's a material shortfall in the council's deliverable supply of housing land over the next 5 years, which results in a demonstrable need for additional housing, which again is not academic, but represents real people and real need for new and better housing. He will explain that housing in this part of Northamptonshire is particularly unaffordable and therefore inaccessible to a significant proportion of the population, with households having to spend on average 8.68 times the median income to assess a median-priced house. That position will only worsen if identified housing needs continue to go unmet. There is currently no plan-led solution to address this problem, and none likely to appear in the short or even the medium term. Indeed, as you'll hear from Mr. Tiley, and regardless of the HLS position, the emerging local plan will fall short of meeting minimum housing needs by no less than 6,538 homes. Thirdly, we say the scheme will make a substantial contribution to housing need. As will be explained below, the appeal proposals will deliver, as you identified in your opening remarks, up to 700 new homes, with 40% of those being affordable. That will make a material contribution and go to a significant way to meeting the above housing need. There will also be a wealth of other important benefits. As again, we expand on, the scheme will provide the new rugby pitch for use by Brackley Rugby Club, the public open space, the allotments that are sought to be provided, the economic benefits, the environmental benefits, and more importantly, all, frankly, in a highly sustainable location which is accessible by alternative means of transport. The impacts are agreed between the planning witnesses to be limited, and we agree with the council that they are outweighed by the benefits, even if you apply the flat balance in the context of NPPF 11. It is notable that for a scheme of this scale, there are no outstanding technical or environmental objections to planning permission being granted, and that is, of course, after 4 years of intense scrutiny and consideration by this local authority. We also say the level of third-party objection for a scheme of this size is remarkably limited. In the light of that scale, the level of hostility often found in relation to new housing and the fact that this is an unallocated site, the level of third-party objection, we say both at application stage and the appeal stage, is remarkably small. In short, sir, as you will hear, there is ample evidence before you from both sides which strongly supports the grant of permission for this appeal. The only remaining dispute between the parties, the main parties, arises not as a result of the concerns regarding the appeal proposals before you, but instead from the council seeking to protect, we say, its position against other planning applications and appeals by refusing to accept that its development plan is out of date. The LPA is concerned, understandably from their perspective, that a concession that the development plan is out of date will be highly consequential for their development management function going forwards and in defending future appeals. But that concern, frankly, is not for this inquiry. What is for you, sir, is whether in the context of October-November 25 and implying the relevant tests and the NPPF, it is credible to contend the development plan is up to date. We say, and we couldn't be firmer or clearer on this, that the position that the development plan is up to date is not credible in circumstances where, of course, the core strategy alone is 11 years old and of some vintage. Secondly, it has not been reviewed for 6 years, contrary to government policy. Thirdly, the adopted housing requirement for the plan is less than the minimum local housing need now established under the standard methodology of December 24. And the LPA has also changed in June 25 its basis for assessing housing land supply to an approach that's contrary to the requirements of the core strategy in using the aggregated method across the whole administrative area of the authority, when, of course, the core strategy was based on disaggregation by looking at 3 different areas. Obviously, the majority of housing was found in Northampton, with the tool and the mechanism of utilising the Northampton-related development areas, which, of course, was land geographically within the old administrative areas of South Northamptonshire and Daventry. The second disaggregated area was South Northamptonshire minus that land related to Northampton. And the third area was obviously Daventry, again, minus the Northampton-related development areas. The fifth point is the plan was adopted, of course, in the context of 2012 NPPF, which has obviously been updated 4 occasions since, most recently in December 24. And lastly, we say and will show that the HLS position shows an absence of adequate supply, whether aggregated or disaggregated, when one considers that the guidance in the MPPG, as Mr. Tiley will do tomorrow, which we say shows a material shortfall in the provision of housing to meet the up-to-date requirement. We therefore say, putting that all together, that the tilted balance in paragraph 11 of the MPPF is engaged for those reasons, and the council's assertion that the plan is up to date and this should be determined on the flat balance is frankly untenable. Dealing with the factual background, sir, the appellants comprise, as you've picked up, 3 separate commercial entities, and they've promoted this site across 5 years and worked together positively and constructively to create a proposed development. The 3 constituent parts are firstly Vulper's Land, which has a record of delivery in their relevant projects. Secondly, Ashfield, who are a major landowner and developer, established some 35 years ago with a track record in delivering schemes across all sectors. And finally, Davidson's Developments, who are leading house builders with 50 years experience and will actually bring about the proposed development and is the delivery partner for the scheme. They have also obviously had input into the master plan and the development proposals to ensure the scheme is deliverable and developable once permission is granted. The chronology I've dealt with, I won't return to that. So as you've picked up, the appeal site is located to the west of Brackley. We say it's immediately adjacent to the existing built-up area, and it is outside, we accept, the settlement boundary, which you'll have seen is identified in the local plan part 2, and it comprises 35 hectares of greenfield land. However, it's not covered by any national or local landscape designations. It's also within flood zone 1, does not contain, nor is it within the setting of any designated heritage assets or indeed non-designated heritage assets, and it is not in or adjacent to any environmentally sensitive area. In short, we say it's not an environmentally sensitive location and the proposed development can take place without any material harm to any designations, heritage assets, or any other identified factors that are recognised in the planning system. As you've identified, the appeal proposals comprise principally 700 residential dwellings, of which 290 or 40% will be affordable. There'll be the vehicular access both at the north and the south. There will be the retention enhancement of Route VA19, which is an existing public right-of-way. There will also be green infrastructure and public open space within the development. That will enable walking and cycling to take place throughout the site. And additionally, there is the 1.5 hectares of land which will provide an extension to Brackley Rugby Football Club, allowing provision of an additional full-size pitch, which will provide the club with a quantitative and qualitative improvement on the existing provision, benefiting the many existing and future members of the rugby club. Lastly, there is the 0.5 hectares of allotment provision. The concept master plan, which you can find at CD805, gives an illustration of how the development can be delivered on the site. Then briefly, just dealing with consideration, as I said previously, the application was made in April 21. A series of extensions of times were subsequently agreed by the appellants, and frankly, sir, I don't think the mechanics of consideration is too material before you, because this isn't a case which, certainly from the appellant's point of view, requires a detailed consideration of how the application was considered. But following the 4 years of engagement with the LPA and the constructive approach, both the LPA and the appellants, but however with no decision, commercial realities left the appellants with no choice but to appeal against non-determination in June 25. In July 25, as I previously pointed out, the LPA's committee resolved that had they determined the application, they would have refused it, but for the putative reason, namely the absence at that time of a Section 106 agreement securing mitigation to offset the impacts of the development or to deliver the commitments in the proposal. However, as I've confirmed the statement of common ground and as the LPA statement of case confirms, this reason of refusal can be overcome by appropriately drafted 106, which we understand is agreed. Development plan is also agreed, and of course it's the joint core strategy in part 2 of the South Northamptonshire local plan. I've set out in Appendix 2 the relevant policies, and what that leads to is that its status and weight and what weight can be given to conflict with those policies that are alleged to be breached is in dispute. We are now in a world where the council are undertaking the beginnings of updating the development plan, but we're not past the Reg 18 consultation stage. Of course, following publication of the amended NPPF, the Council published a revised LDS in February 25, which envisaged publication of the further draft 18 in October 25. Our understanding, and we're very happy to be contradicted, is that draft has not yet emerged. But sir, with your professional background, you will not be surprised, and you're not allowed to smile if I say that isn't the first LDS deadline to be not hit for whatever reason in the history of the emerging development plans. So the planning balance to be applied, the starting point, of course, and as summarised in your main issue in the case management conference and reiterated by you this morning, is obviously one, whether the proposed development complies with the development plan, and if not, or if it does, whether there are any other material considerations to justify a decision than otherwise in accordance with the development plan. The parties agree that there is conflict with the development plan in terms of location of the development outside of the defined settlement boundaries and the acknowledged limited landscape harm. They also agree that this limited conflict is outweighed by other material considerations such that planning permission should be granted. Of course, they disagree on whether other material considerations include application of the so-called tilted balance. As I've said, we are of the view the development plan is out of date and the tilted balance is engaged for reasons of age, lack of consistency with the NPPF, failure to undertake a review, the increasing housing requirement, the switch by the LPA and how they assess housing within the district, and lastly, the current inability to demonstrate a 5-year HLS. In terms of the age, the plan, the joint core strategy, which was evolved by the planning unit, was submitted for examination in December 2012, with elements of its evidence base predating the publication of the NPPF. The examining inspector's report, which Ms. Butterfield has appended as Appendix 3, concluded the proposed housing target did not represent the fully objectively assessed local needs for housing as required by the NPPF. This was largely because the plan relied on out-of-date evidence base that had not been properly reconsidered in light of current needs and circumstances. The local plan part 2, which of course is the daughter document to the joint core strategy, and similarly does not respond to the full objectively assessed need for housing, was also examined against the 2012 NPPF pursuant to transitional arrangements in the 2018 version, despite being adopted in 2020. Both documents were therefore adopted in a very different national planning context, particularly in relation to identifying local housing needs. The JCS was reviewed in 2019. I think we give a date in Ms. Butterfield's evidence of December 2019. Mr. Callis gives the evidence, says January 2020. I don't think it's critical. Many of its policies were found to be in need of review in order to accord with the NPPF as it stood at the time, but subsequent amendments to the NPPF can only have made the need for such a review more pronounced, and yet still no amended plan has come forward in 6 years. Therefore, not only is the development plan more than 5 years old, but it fails to comply with the NPPF in that it does not provide for objectively assessed housing needs as a minimum as required by para 11B, or provide a framework for meeting housing needs and up-to-date plans are required to do, make sufficient provision for housing in accordance with para 20A, provide a clear strategy for bringing sufficient land forward at a sufficient rate to address the objectively assessed need over the planned period, as per para 23, or finally ensure that sufficient number and range of houses can be provided to meet the needs of present and future generations in accordance with para 8B. Therefore, we say you should conclude that it can be considered substantially out of date on that basis, regardless of the housing land supply. But as you're here tomorrow dealing with HLS, the development plan was very much adopted on the premise that 5-year housing land supply should be calculated separately for each sub-area, with South Northamptonshire being the relevant sub-area for this appeal. The PPG requires that HLS continue to be assessed in accordance with that premise despite the subsequent reorganisation. To conclude, as the LPA commends you to do, that the HLS is to be assessed for a different area would be to entirely disregard the spatial strategy of the development plan and the policies which flow from it on the basis they are entirely out of date. This would, in the appellant's submission, be another basis for engaging the tilted balance, regardless of the HLS position. Previously, the LPA agreed with Mr. Tiley's approach and calculated the supply separately for South Northamptonshire in all of its 5-year supply assessments. Yet in June 25, it published a new assessment, which is a core document, which of course now calculates the supply for all of West Northamptonshire in aggregate, contrary to the development plan and the PPG. Mr. Tiley's approach results in the need for 469 homes per annum in South Northamptonshire, which of course mathematically, if you times it by 5, gives you a figure of 2,345 for 5 years. Adding the buffer shows the requirement for South Northamptonshire as 2,462. And his evidence will show that against that requirement, there is a deliverable supply of only 1,840 homes, which means that the HLS position for South Northamptonshire is 3.74 years. We say the LPA has not presented any contrary evidence on the supply for South Northamptonshire. Then we deal with the West Northamptonshire position, which Mr. Tiley has also presented evidence on. And he again says there's a significant deficit with only a 3.73 year deliverable supply. The LPA disputes this and argues it can in fact show a 5.3 year supply. The two key points of dispute giving rise to the difference of the figure, of course, are that the LPA use, we say contrary to the PPG, of 2023 housing stock data rather than the latest information from 2024. And secondly, there's disagreement and no surprises to the delivery of a large number of sites detailed in the Scott schedule. I think there are 57 from memory. Stepping back, the appellant's case will be that the development plan policies are both substantially out of date due to their age and lack of consistency, and deemed out of date pursuant to footnote 8 due to the LPA's inability to demonstrate a 5-year housing land supply. Accordingly, the appeal should be determined applying a tilted balance, requiring you to consider that planning permission should be granted unless the adverse impacts of the proposals would significantly and demonstrably outweigh the benefits. Therefore, can I turn to the benefits and impacts of the proposal, which hopefully are largely agreed between the main parties. The first benefit is, of course, delivery of up to 700 new homes, and as set out above, there is this urgent need, and that's reflected in the MPPF, which is the government's objective to significantly boost the supply of homes. Mr. Tiley's evidence demonstrates that the need exists locally as well. The housing would be delivered by this scheme, which would make a material contribution to the Council's 5-year housing land supply deficit, and therefore the parties agree that very significant weight can be attributed to this as a benefit. The second benefit is that 40% of homes will be affordable. Again, there is a shortage of affordable housing both nationally and clear difficulties with affordability of homes at a local level. Ms. Butterfield refers to in her proof the LPA's latest monitoring report, which indicates that permissions in Brackley and Towcester only resulted in 12.5% affordable housing delivery. In that context, she affords very significant weight to the delivery of affordable housing. Then economic benefits, and you'll be familiar, so with Para 85 and the need to support economic growth and productivity, taking into account both local business needs and wider opportunities for development. The appeal proposal will, of course, achieve this by the construction employment opportunities, contributions to economic output in construction phase, the expenditure of the new residents and the development in the local economy, and council tax revenues. Again, the parties agree significant weight can be attributed to the construction phase benefits, and Ms. Butterfield attaches additional limited weight to new residential contributions to the local economy. Then environmental benefits. In addition to delivering housing on a site that is environmentally preferable in terms of its low sensitivity, the proposals will deliver two positive environmental benefits. There'll be an on-site biodiversity net gain and the provision of the allotments. Both parties agree these should get limited weight. Then the rugby club, and we say the importance of sport for the health and well-being of communities is recognised in the MPPF at Para 103. The need to expand the rugby club through the provision of extra pitch space is identified in the Council's 2011 playing pitch strategy. Ms. Butterfield attaches limited weight to the benefit. Then the open space, and the proposal will deliver a quantum of 10.57 hectares of open space, well in excess of what policy seeks, which would be 4.03 hectares. The parties agree that this should get significant weight, and it includes the provision of play spaces on site, which the parties agree merits additional limited weight. The seventh benefit is we agree, the parties, that Brackley is one of the most sustainable locations within West Northamptonshire, with an abundance of established services and facilities that are set out in the main statement of common ground. The appeal site is immediately adjacent to the settlement and provides direct access to those services and facilities. Further, the proposal will provide high-quality walking and cycling networks with links to adjacent areas, uses and facilities which will encourage sustainable patterns of travel in accordance with para 110 of the MPPF. The parties agree that this benefit should be afforded significant weight. Then lastly, high quality design, and you will have seen the design statement prepared by Mr. Vernon Smith, Appendix 1 to Ms. Butterfield's proof, which sets out how the proposals comply with all relevant local and national design policies and guidance. This is a matter to which Ms. Butterfield affords limited weight. Cumulatively, adding those 8 benefits together, we say are very weighty in any planning balance, whether the tilted or flat balance is applied. Then moving across, if you could bring your spotted handkerchief, sir, with you to cross the planning balance, and I'll go to impacts. There are 3. The first is conflict with the spatial strategy. And of course, as the appellant accepts, we're dealing with greenfield land outside of the settlement boundary, and therefore conflicts with the spatial strategy established by JCS Policy S1 and Local Plan Part 2 Policy SS1. On its face, this is a breach of the plan. Nonetheless, as discussed above, the site is in a highly sustainable location which will minimise the need to travel by car, thereby according with a number of other development plan policies on the location of development. Further, we have also detailed above the appellant's view that the development plan is out of date. For those reasons, Ms. Butterfield's judgment, as you'll hear on Thursday, is that only limited weight should be attached to this adverse impact. Landscape harm. The appeal proposal, as is the case for any development of a greenfield site, will necessarily result in a degree of landscape impact within the immediate context of the site. However, the relevant chapter of the ES confirms that all identified significant effects are localised in the nature. Accordingly, again, Ms. Butterfield affords only limited weight to this impact. Then lastly, in terms of impact noise, no objection on the proposed development on grounds of noise, and no allegation of conflict with any development plan policy, but there will be noise impacts during construction, which will be of limited duration, and in the operational phase, subject to adequate mitigation to avoid any significant adverse effects to occupiers or neighbours, and that again gets limited weight. So to conclude these opening remarks, the appellant's case before this inquiry will be that the cumulative benefits of the proposal are very significant indeed, will be very clearly outweigh the limited adverse impacts regardless of whether you seek to apply a flat or tilted balance. Nonetheless, we will seek to persuade you and demonstrate that the development plan is out of date for the reasons identified in these submissions, and accordingly the tilted balance is engaged. When the balance is considered, the position is even more stark. Evidently, the limited harms identified by the main parties do not significantly and demonstrably outweigh the overwhelming benefits of the proposal. So to conclude, sir, we urge upon you, after considering the evidence, to allow the appeal and therefore grant permission for this much needed and frankly long-awaited development to come forward. So unless you've got any queries on the opening submissions, those are the opening submissions. I think there's one amendment, sorry, that my learned junior has picked up. If I could just ask you to go to 15.2. And I'm sorry, 290, the affordable housing should actually be 280, I'm told.
Thank you, Mr. White.
That's why I got a
Yep.
U in my, actually it wasn't quite as bad as a U, but I won't tell you what my O-level maths was. Thank you, sir.
No problem. Thank you. I've no questions, obviously, on the opening submissions, Mr. White. Thank you for that. And if we can just at lunchtime ensure that that goes on the inquiry website, that will be appreciated. Thank you. Right, on behalf of the council then, in terms of opening submissions, Mr. Fraser.
Yes, sir. I have the written text distributed for you now, sir.
Thank you. Thanks ever so much.
I think one or two members of the public may need to share, because we haven't printed a vast number of these.
And like I mentioned earlier, I'll record this as ID2. And please commence when you're ready.
Thank you very much, sir. I've set out for formal purposes the development for which permission is sought, and I've recorded in the briefest terms the history of the matter. That's most unusual that my voice is not heard. But there we
Is
are.
that okay?
Thank you, sir. As I said, I set out for formal purposes the description of the development for which permission is sought and record in brief terms the history of the determination of the application. And I record at paragraph 3 the single putative reason for refusal which the council brought forward, which was based upon the lack at that time of an acceptable Section 106 agreement to secure the various mitigations which were necessary to make the scheme acceptable. Since that time, however, an acceptable Section 106 agreement has been entered into, and the council's putative reason for refusal falls away. Accordingly, the position of both parties is that planning permission ought to be granted. I note, sir, that you've referred on a couple of occasions to the council's position being neutral. That's not quite right. The council's position is that with that Section 106 in place, the planning permission ought to be granted. The dispute between the parties is as to the route, and that's route as in road rather than route as in part of a tree. My reliance on dictation software is exposed there, sir. But the dispute is as to the route by which that planning permission ought to be granted. In reality, however, one has to note that the inquiry will be in receipt of expert evidence from both parties, which suggests that whatever route is taken, planning permission ought to be granted. And as such, the reality is that the issue between the parties does not strictly need to be resolved by you in order for you, sir, to come to a decision on this appeal. Nevertheless, a dispute does exist. The council contends that the development plan is not out of date and should continue to apply with full force. Notwithstanding that starting point, the council concludes that the benefits of the scheme outweigh the undoubted breach of development plan policy which the scheme represents. As such, even on a normal or flat planning balance, permission ought to be granted. Now, our evidence will develop this position. The spatial strategy of the development plan envisages that development will be brought forward in sustainable locations in accordance with a tiered hierarchy in which Brackley sits below Northampton and Daventry. The appeal site is outside the settlement boundary of Brackley in an area where the development of housing is strictly controlled. Accordingly, the development is in breach of the locational criteria of the development plan. However, the development is considered to be in a sustainable location, being immediately adjacent to the settlement boundary of Brackley, and brings with it significant benefits, including the delivery of market and affordable housing, improved public transport, walking and cycling links, land for a new rugby pitch for Brackley Rugby Club, provision of allotments, public open space, and designated play areas, non-statutory biodiversity net gains, and a contribution to the economy through investment in construction, employment opportunities, and household expenditure. In addition, the environmental and other impacts of the scheme have been properly assessed by the appellants and are limited. None are sufficient to justify refusal. Accordingly, notwithstanding that breach of the development plan's locational criteria, the council's evidence will demonstrate that the planning balance, when applied on a flat basis, indicates that planning permission ought to be granted. And unsurprisingly, the appellants agree with that assessment. However, the appellants assert that the policies of the development plan most important for determining the application are out of date, and accordingly the tilted planning balance in NPPF paragraph 11D applies. Accordingly, planning permission, they say, ought to be granted unless the harm caused by the scheme significantly and demonstrably outweighs the benefits. We, the council, disagree with that. The appellants appear to assert that the relevant policies are out of date for the following reasons. Firstly, the council, they say, is unable to demonstrate a 5-year supply of deliverable housing land such that the automatic provisions of footnote 8 to the NPPF apply. Secondly, it's said that it is more than 5 years since the development plan was adopted and no review has taken place within the last 5 years. Thirdly, following the adoption of the standard methodology in the December 2024 NPPF, the local housing need exceeds the housing numbers provided for in the development plan. Then, the adoption of a calculation by the council of its housing land supply position, which is based upon an aggregation of the housing land supply position across the whole of West Northamptonshire, rather than in respect of the areas of the three previous authorities which have combined to make up West Northamptonshire, means that the spatial strategy which underlay the adopted plan must, they say, by definition have been abandoned. And finally, reliance is placed on the wording of paragraph 232 of the MPPF, which deals with the transitional provisions resulting from the changes made by the December 2024 iteration of the MPPF. That wording, they say, indicates that the development plan must be out of date as it has not been reviewed within the last 5 years. And so we will demonstrate through evidence and submission that each of these propositions are wrong. Firstly, with respect to the 5-year supply, the appellants suggest that the housing land supply should still be calculated with respect to the previously existing areas based upon the three authorities which are now combined. This, however, we say is a self-serving position, which is neither logical nor allows for the use of the most up-to-date information. Furthermore, and as is often the case with developers, the approach adopted to the scrutiny of individual sites, as will be seen in the Housing Roundtable session, is again self-serving and unrealistic. When considered against the appropriate area for the calculation of housing land supply, and with a sensible approach to individual sites, it will emerge clearly that the Council does have a 5-year supply. As to the matter of the age of the adopted plan and the absence of recent review, the Council will demonstrate that this part of the appellant's case is contrary to well-established law and planning practice. With respect to the increase in local housing needs since the December 2024 NPPF, whilst it is accepted that the stated numbers in the adopted development plan do now fall short of the local housing need, that is not the relevant matter. The issue is the consistency of the plan with the NPPF generally and its ability to deliver the required housing numbers. The Council will demonstrate, not least because it has a 5-year supply even as against the new local housing need, that the policies of the development plan remain consistent with the NPPF and thus not out of date. With respect to the purported abandonment of the spatial strategy, this is clearly not the case. Whilst the precise numbers suggested for each part of the hierarchy of the spatial strategy are no longer relevant, the basic approach of the spatial strategy in delivering development sustainably through a tiered hierarchy remains entirely relevant and consistent with the overall objective of the MPPF of delivering housing in a sustainable manner. And finally, we will demonstrate that the approach adopted by the appellants to paragraph 232 of the MPPF is erroneous. The emphasis of that paragraph is on the consistency of an adopted development plan with the NPPF and the ability of the plan to deliver, through the mechanism of maintaining a 5-year supply, the necessary levels of housing. When considered properly against those tests, the development plan remains up to date. Accordingly, we will suggest that there is no basis upon which the tilted balance should apply. The matter should, as set out above, be determined on a normal flat balance. However, we do agree that if the tilted balance applies, the harm from the scheme does not significantly and demonstrably outweigh the benefits, and planning permission ought to be granted. And as such, sir, you will note that the expert planning evidence from both sides suggests that whatever approach is taken to the planning balance, flat or tilted, planning permission ought to be granted. And in truth, that latter conclusion is all, in fact, that you require, sir, in order to be satisfied that you should grant planning permission. So unless I can assist further with those.
Thank you for that.
The opening statement.
All right. I think that's probably an appropriate time now to take a break. That concludes opening submissions. It's 11:24. I think we'll take a 15-minute break. So if we resume back in this room at 11:40, and we'll start with interested parties presenting their thoughts to the inquiry. I'll go through that list again, so you know the speaking order when we do resume. But at that point, it's now 11:24 by my computer clock. We'll adjourn at that point and we'll resume at 11:40. Thank you. Right, welcome back, everyone. It's now 11:40. The inquiry is now resumed. At this point, we'll hear from interested parties who want to speak to the inquiry. I'll just go through the list again before I invite the first person to come to the witness table. So we'll start with Councillor Fiona Baker. Then we've got Mike Graves, John Brooks from the Brackley Angling Club, Alan Mays from CPRE, and then Kevin Blencow. If Kevin Blencow's here. Blencow. Right, it's just right, no problem. Blencow. No problem. Thank you, Mr. Blencow. So we'll have that order. Can I please invite Councillor Baker to come to the witness table? I'm sure you're very familiar with the microphone system, Councillor Baker, so I probably don't need to say anything to you about that.
I am indeed, thank you.
Just before you start, a couple of questions that I said I would ask. First of
Yep.
all, confirm your position in terms of supporting or opposition to the application.
I am the Brackley Ward Councillor,
Yep.
have been for 18 years.
Yep.
I know Brackley well.
And are you support or in opposition? Are you
Opposition.
opposition? Next thing I need to ask, if you do have any speaking notes that you'd like to give me or send to the Pins case officer, then please do so. I'll record those as inquiry documents and we put on the website. And then the last point that I said I would ask is, Mr. White may have some questions for you. He may not. Would you be prepared to answer those questions? You don't
Yes.
have to do.
Yes,
Thank you.
of course.
Can I just say, sorry, I should have said this before, but my general house style is not to ask questions of third parties for obvious reasons. So
Yep, that's fine. Advocates normally don't, but I have to ask in
of
case.
course you do.
Um,
But I just wanted to give you an indication because I
Yeah.
know some of our brave or more take a slightly more interventionist approach,
do.
but I don't.
No problem. So you're not going to be asked questions anyway, but that sounds a bit. So when you're ready, please commence and I'll make some notes.
Thank you. I will send you my notes later if that's all right.
That's
I have
brilliant.
changed my thoughts having heard from these two gentlemen here.
Okay, thank you.
As I said, I'm speaking as a Brackley Ward councillor for many years, representing the dozens and dozens of emails and messages and social media posts I have received from Brackley residents. As already stated, we have been through many, many challenging planning times in Brackley. When I was first involved with Brackley 20 years ago, there were just under 8,000 residents. We are now just over 18,000 residents, so I do not think we can be accused of being NIMBYs. It's a shame that these things are decided by people who do not live and have experience of the area. We have had many years of building large developments in our small market town. Over the past 10 years, we've had the building of the new development to the north of the town, where the roads for these developments have not yet been adopted by WNC due to issues with the drains. I fully understand and I'm well aware of the government stipulations that we need to have more than our previous allocation in South Northants. However, many residents do feel that we in Brackley have done our bit. We've had only one new primary school during this time, and we have had one school closed by the Department of Education and no new secondary school at all. We have a shortage of doctors' surgeries and no capacity for dental appointments on the NHS at all. It's very hard to see the benefits that were spoken of earlier. We have a very poor bus service that comes in one end of the town and goes straight out the other and does not access the town at all, with problems getting young people at secondary age to schools in other areas. We also have no local access to train stations. This development has shown an outline for access to the site, which all in Brackley will be a major issue. This is our major concern. The roundabout at the bottom of Banbury Road on the A422 is already, and was this morning, heavily congested at peak times, and there is no good plan other than to add another road to this roundabout to access the site. The angle proposed is so sharp it will virtually mean doubling back on the A422 to access the land available. The other end of the site accesses the Holt Road, which is a country road currently with no white line down the middle, leading to Hulse Village, or the north of Brackley, which is already highly congested. The Poppy Fields Way, our latest development, which already has traffic issues. This is a major issue with flooding and drainage, and West Brackley, Humphreys Drive development, flooded in the past, as all of these developments are uphill from the road system down at the A422 is very much lower down. I've received grave concerns from the Angling Club, but I won't go into those because I understand they're speaking to you themselves about the flow of water that will be taken from this development. As well as taking much needed green space away from our town, it has the potential of putting at least another 1,400 cars on the road around our town. There is no good plan, in my view, for S106 contributions to benefit the town other than enlarging the rugby club, who already do have a sizable rugby pitch. What was a really nice town to live in with green spaces and a great community spirit is fast becoming a town where people live and exit every day for Milton Keynes, Northampton, Oxford, and further afield, London, Birmingham, and many more. In other words, a dormitory town. We do not have enough employment to support more people locally. We have one large employer, who you may well know, whose workforce is very specialist, and many travel to that site, as we all see on the A43 traffic in the morning coming in from other areas. At peak times of the day, there are large lines of traffic on the roads out of Brackley to access the A43, A422, M40, M1. I understand that our problem is that we are plop in the middle of all those road accesses, which makes it more difficult for those that live there. But that's why people live there. They can easily access other areas. The application is outside the boundary settlement of the town on greenfield land and in breach of the strategy. This site will not really contribute to the explained needs of those on the housing list. As I well know, just to explain that my previous role for 6 years was lead for children, families and education, and I'm well versed with the social housing issues. Affordable housing, as advertised and addressed, means that young people who save up a large amount of money for a deposit can afford to buy a house. In no way does that go towards social housing or those people, unfortunately, living in poor conditions currently. Social housing is what we need, not affordable. We also have HS2, as you will see when you visit the site, right on our doorstep, which we have suffered development for many years. I'm hard-pressed to see where the benefit outweighs the disadvantages, as mentioned many, many times by our colleague here, as I'm sure many residents will agree with me. I do emphasise when you do your site visit that you do look very carefully at both the road accesses to the site, both at the bottom and the top, because this is the major concern above all of the other things that I've addressed to you today for the residents of Brackley. Thank you very much.
Thank you very much, Councillor Baker. I will just confirm, and I know you've said it, but I will ask each time, just in case, Mr. White, that you've no further questions for Councillor Baker. Thank you very much indeed. Thank you for your contribution, Councillor Baker. And if you can send those comments to the Pins case, that will be appreciated. Thank you. The next person that I have on my list to speak is Mike Graves on behalf of the Angling Club. Mr. Graves, if you can take your position at the inquiry at the witness table, I will ask you exactly the same questions that I asked Councillor Baker as well about your position in the application, etc. But I'll let you settle down first. Do you have some handouts to give us, or? That's okay. I need one and both parties need one. And just tell, when you sit down, you can tell us what these are. So if you can ensure that the appellant has a copy of that and that the council has a copy of that, if you've got 4. It's the large button in the middle,
That one.
Mr. Graves, that's the one. First of all, Can you tell me who you represent and your position on the application?
Yeah, my name's Mike Graves and I represent Brackley Angling Club. I'm the permit secretary.
And your position on this application is one on?
Of
you oppose
objection.
it? Yep. Before I ask you about any questions that you might be asked, can you just tell me what you've handed out to us today?
Yeah, it's a shortened version of a report that I sent to your office about a week and a half ago, and I was told by Mrs. or Miss Fay Tew, T-E-W, that the information we supplied cannot be accepted because it was sent to you after the 28th of July deadline. However, we didn't even know that we could raise objections. The first we heard of it was 2 weeks ago. So this is something that's ongoing. Northampton Council and Brackley Town Council and Anglian Water and the Environment Agency are aware of these issues. I've been reporting these issues for the last 3 years to all the aforementioned.
Just before you stray into what you might say, so this is not what you sent to the planning inspectorate, is it?
Yes, it is. It's a shortened version because the version that I've sent has got a lot more photographs and I
Right.
couldn't document them.
This is addressed to the council.
This is addressed to the planning inspectorate of Northampton, West Northampton Council, yeah.
Ah. There lies the issue. It's not been sent to the planning inspectorate. It's been sent to the council.
I have an email saying it was forwarded to you.
Was it?
Thank you, sir.
Because it's not registered as an out of time system.
Yeah, I'll just have to double check on that. I do believe that it was submitted to the council. As to the exact details of what then happened, I'll have to double check, but it was only submitted, as he says, in after the deadline for comments to pins.
So this is an abridged version of what you.
Yeah, because the version that the actual full report is way too big to
Okay.
It's full of photographs and photograph evidence of the environmental impact of what's happening now at our site.
All right. What I will say on that is that usually we have a file with out of time responses, and I checked that at the break and I couldn't find the response from the.
I could email it to you. I can email it. I've got it on my phone now. I can
It's
email it to you.
okay. No, it's okay. So if you send it to Tim, I can make a judgment today as whether or
Right,
not I need to just look at that
Yeah.
and put it back into the public access file.
Okay.
But I'll make that judgment having heard what you say.
Yeah.
But what I understand is what you're going to say today is a bridge version effectively of what you've
Yeah,
sent in.
because I realise that I've only got a short amount of time.
All right. So
Before this representative, can I just notice that this is actually written by a solicitor and it's 4 pages long. I don't object. Obviously, this is the first time we've seen it, but can I just reserve the ability to ask, it's largely, if not completely, about the proposed drainage and the consequences of the proposal. Can I just reserve the ability, obviously, to ask those that are instructed by my clients on such matters to whether they need or want to comment on it, and I will put in a written submission by Thursday.
that's
But
fine.
obviously, having not seen it until now, I'm not in a position to say whether we will need to or we won't.
Yep.
But I want to make it clear, I don't object to its production or you hearing it, but I just reserve the right, and the council might want to whether we have the opportunity to come back on it.
That's fine. I would expect you to have said that, Mr. White, because it's the first time I've seen it too. That's why I looked on our back office system to see if I'd seen the original. But I haven't. So it's new information to all of us. So I don't mind whether it's a joint position statement that the council and the appellant produces in response to this is something I'll give you the opportunity.
Yeah, I mean,
We'll touch upon that probably tomorrow when you've had a chance to have a think about it overnight, perhaps.
Yeah,
Okay.
I mean, we would have admittedly submitted it earlier if we'd have known about it, but we
Yeah,
didn't.
no, I appreciate that. And
And we feel that strongly that the information that we've
Yep.
put forward needs to be seen by the appropriate people.
but we are where we are now.
Okay.
So if you can, I
Okay.
assume you're not repeating this. This is for information. This is not what you were saying to us today, is it? Or is what you're going to say based on that?
What I'm going to say is based on this. So you've got an idea of
All right.
what I'm talking about.
In which case, the last thing I need to ask you, just in case, Mr. White might have some questions for you, prepare to answer those questions.
Yeah, I've got, as long as I have the
The ability.
answers to, and the ability to answer
Yeah.
that, I've got no problems.
No problem.
Yeah.
All right. Commence presentation when you're ready.
Brackley Angling Club is a non-profit angling club which serves the community of Brackley. We have a wide range of anglers of all skill levels, children to adults to pensioners. We're also involved with the local health authority now because mental health issues and fishing is prescribed as a treatment for certain cases of mental health issues. So we're involved with all aspects of the community. And over the last 5 or 6 years, we've seen an increase in flooding down at Brackley Lake. Now, we have read the drainage reports. My colleague, chairman, who's going to speak after me, knows more details about that, so he'll touch on that when he speaks. And our representative of Fish Legal deals with this all the time. So he's read the full planning report, and through his analysis, we've obviously based our argument. From what I can gather from the environmental impact reports, they talk about no environmental impact on the site. However, nobody's talking about the water and the drainage once it leaves the site. An unnamed watercourse is mentioned. That unnamed watercourse is the river that runs behind St James Lake, which is approximately 0.82 kilometres from the furthest point of the housing estate or proposed housing estate. The water will then leave the site and it will make its way into that river, which will then obviously flow past St James's Lake. Now, St James's Lake was built in 1976 to deal with the flood and surface water from the then new estate, which is the French estate, Banbury Road and the Wainfleet estate. We've had 40 years of new housing, and all of the water that's taken from those housing estates, which are basically an extension of the French estate, now ends up in St James's Lake, and it cannot cope with it now. You'll see from some of the photographs that I've supplied, they're only a fraction of the photographic evidence that we have of the flooding. This flood that I've pictured here was one of 5 last year between the beginning of April and the end of April. We had 5 floods like that in 1 month. And they're getting closer and closer to properties that are built around the lake. And the last one, the one documented, came within 20 feet of people's residences. Now, between the proposed site and the new site that has just been completed or just about to be completed, named Lake View or Field View, sorry, which was just been completed to the I think it's the end of St James's Lake site, the top end. I'm not sure whether it is geographically, but it's a brand new housing estate. Now, between the housing estate that's been proposed and this housing estate is a Anglian Water sewage pump house. This sewage pump house flooded into the local river system, the one that passes St James's Lake in 2017. And Anglian Water was sued and had to pay £560,000 for damages which was caused by this pollution. It killed 5,000 fish and destroyed the river from Brackley all the way to Buckingham. It's only now, in fact, last year we worked with a local resident to get the Environment Agency to restock with fish. So it's been dormant and practically dead for the last 8 years. And we were extremely lucky that the river did not overflow into the lake. If it had overflowed into the lake and backwashed like it did in these photographs, we would be dealing with an absolute catastrophe. There'd be thousands of fish dead. We've lost wildlife, all sorts, which my colleague will allude to when he speaks. The flooding is getting worse and worse. It's now causing structural issues with the lake as bankside material is being washed away. And last year we had an angler slip on uneven ground that's been washed away, and he broke his leg. It was that bad that he nearly had his leg amputated. Thankfully he's all right, but this is being caused, bank erosion. And like I said, lots of people, not just anglers, use the lake. We have dog walkers, we have people exercising, we have mental health groups walking around, and they're being denied access to the lake when it floods. We've recently also had a footpath in 2017, which was paid for, I think, in part by the council. This is now suffering. It was cost £90,000, and it's now suffering damage. It's being washed away. This will need replacing. Like I said, we don't have the funds to do that. We think that if this housing estate is to go ahead, my personal objections would be, I don't want it to go ahead for the reasons that the councillor before me spoke of. But if it is to go ahead, then the drainage seriously needs to be looked at, because once the water leaves that site, it's going to end up in the river. And the lake that we have currently is incapable of dealing with floodwater now, due to the river being mismanaged. It's overgrown with vegetation. It's affecting the flow, and the flow is then obviously going in different directions. It's affecting the farm on the opposite side of the river. Is having land washed away because the river changes course because of the vegetation that's changing the flow of the river. It's causing all sorts of issues. And last year, that flood that I've photographed here, the river runs past our site, round the corner for about 200 metres, and then runs in front of the Tesco's supermarket. And the river in front, that's the last photograph you'll see there, is the river in front of Tesco's superstore. That burst its banks and caused Tesco's to close. Now, we believe that the drainage is not really being serviced to a standard which keeps the flow of water sufficient, that it doesn't cause any issues. And this is, potentially in the future, whoever gets the contract, how can we be assured that they're going to clear the drainage to acceptable standard? So yeah, that's basically all I need to say. It seriously needs to be looked at, the drainage solutions. And also, I live 5 minutes from the site. I walk my dog around the site. So on Thursday, if you want, I can show you some of the photos and point them out to you, because large parts of that site that's proposed is underwater for 3 months of the winter. It's got a very high water table. And our lawyer or our solicitors who looked at the plans doesn't believe that what's proposed with the drainage ponds is sufficient to deal with the water, which will run off surface water from the site. So that's basically it. Any questions?
Thank you for that. I probably need to have a think about this, I think, Mr. White, don't we, in terms of whether or not the extent to which these issues have been captured in the information already provided, the drainage strategy. It seems to me that with respect to the
I should make you aware, Angle and Water are aware of this, and they are investigating it. That they are looking at the issues with what we've raised with regards to the flooding and damage to the structure of the lake.
It might be helpful to me for perhaps a note in response to this to come probably by lunchtime Thursday, if we can. If not, we can send it afterwards. Probably in discussion with the council. Also, just on the site visit itinerary, I don't think we're going to go near this, are we? Or are we? You know the area far better than I do. But the point I'm making is we probably need to have a look at this area on the site visit. We can.
Okay, yeah, I'm sure we can update the itinerary to include that. It's not in the current itinerary to visit this specific location.
But it's just maybe worth it, because obviously if there is an issue that there's a serious concern about drainage that's coming from the proposed development to St James Lake and the effect it has on the river in the vicinity of St James Lake, then we probably just need to have a look, in my mind, then to put into context the pictures.
Where the top field of the site, again, I draw your attention to the report I've sent electronically. It's got all the photographs of the site, every field that you've got houses proposed to be built on. And I've basically, because I walk my dog around those fields and then down to the lake, it's about 3 or 4 kilometre walk and it's all downhill. And I've highlighted basically the journey the water is going to take from that site to the lake. And I can basically attend the meeting on Thursday and just point out what I'm talking about. So you've got an idea of what's going on, and you'll see that at least 2 of the fields, there's at least a third of, well, maybe a quarter of the top 2 fields that never get planted with seeds because it's underwater. The farmer doesn't sow seeds because it's that waterlogged. It's up to 2 feet deep on some places, and that water needs to go somewhere. And we're not convinced that the drainage proposals are sufficient to deal with that.
Okay, what we're going to do then, asking the appellant and the council to produce a note for Thursday lunchtime if we can, if not, technical note afterwards.
Yeah.
Just in response to what you said and what you've seen and what you've photographed. So that's point 1. Point 2, we'll have a look at the site visit itinerary to see whether or not we can visit this particular part of the site. So if you can just have a think, what the appellant to the council as to where we would park, where this would fit in the site visit. I'm mindful, of course, of it gets dark earlier now, so we need to think about how we can do this efficiently. But I'll leave that in your capable hands, is to have a think about how best to.
There is parking
visit.
Down at the lake if you want to visit the lake. There is
I think
sufficient parking.
I think I need to visit the lake.
Yeah, you could see firsthand some of the damage that's been done to the banks and the footpath and stuff like that, and quite happy to show you that.
Okay.
I do believe you have all my contact details, so if you need to get in contact, just obviously let me know.
It won't be me.
Well, no, whoever's going to be contacting me.
All right. Okay.
But can I deal with the procedural point?
Yep.
I'm just concerned that there seems to be, there's reference to what you handed out, and there was also, am I right in thinking you referred to other material as well?
Yes, this is a short and condensed. Basically, what you're missing is just photographs.
Just in view of answering, but where is the other information? Because so that's not before you, but it's been referred to, and is it anywhere?
Northampton Council
Okay, well, could I ask if you this afternoon sent to Mr. Callis everything you want the inspector to?
If you give me the appropriate address, I've got no problems with doing that.
Well, Mr. Callis, I just want to have absolute certainty that we've got everything, because in one email, so both for you and also I'm in the position of having to send it on to my flooding consultants. So I want to make sure they have everything you have. So could I just ask this afternoon, if you ask Mr. Callis for his email, could you send a complete email of what you've handed out and the other documents you've referred to? And could you in the email identify what you're sending so Mr. Callis can do it, make sure everything's there?
Okay.
And then he'll send it to the parties.
No worries.
And then, sir, in relation to us, I mean, there are 2 points I want to make. The first point is, of course, we'll aim, obviously, until we see the extent of the material, we will aim for Thursday lunchtime, point 1. Just to also, could you take a note though, and I don't know to what extent you've seen this, but there is an addendum to the flood risk assessment and drainage statement of April 25, which was before the council. So the documentation has been updated from 21 to 25. But I will make sure that Ridge, who will respond to this, refer to that. But I think the best way forward, if we can agree, get all the information, we will then respond to it. We might try and, as you say, a joint response from the council as well, so we have an agreed position. But it might be that timetable is ambitious because the council, Mr. Callis, will obviously have to send it to those that are knowledgeable on such matters, but we will aim to hit that.
I think what we'll do, we'll take a position on Thursday. If we can do it on Thursday, all well and good. If not, we'll allow some time afterwards because we're not going to close because we still need the section 106 completing. So we'll give you some time to respond to that. It's not something that's going in the public domain for further comment. It's something that comes back to me part of the inquiry. So we'll do it in that format. I don't have anything else. I'd check to see on our website, see if we've got anything that been submitted, but not out of time, and there's nothing on our website. So you have what I have for the first time today also.
And so just for your note, the reference I gave you is CDA 40 is the addendum to the flood risk assessment.
Yep.
So I should have given you that reference earlier.
No problem. All right, so we're going to get the council and the appellant to just have a look at what you've sent, because none of us effectively have seen it.
Yep.
And the sense check is whether or not the drainage strategy recognises some of the issues that you've raised, and therefore in its design is accommodating those issues to ensure there's no detriment to the watercourse and to the fishing lake as a consequence of proposed development. So that's probably as far as we can go today.
No, that's fair enough. I mean, we understand, first of all, it's a balancing lake, you know, and it's built for this, but it's not, it was built for dealing with water, surface water, like from the housing estates 40 years ago, not now.
It's
It just
a
can't
capacity issue.
Yes, it just can't compare. And when the river washes, because it backwashes into the lake, the river backwashes into the lake and it's bringing in farm washed land full of phosphates and mud back into the lake, which is now filling the lake with silt. So it's an ever increasing risk because the silt buildup is causing the volume to shrink, which is then causing more and more flooding.
All right, thank you for those contributions. I'm going to record,
Thank
even
you,
though I
Tom.
know there's going to be some more detail, I'll record those as ID3 because they've been submitted today as an inquiry document. So I'll record those as ID3, the photographs and the letter from Legal Fish or Fish Legal. Thank you very much, Mr. Graves. Thank you. Can I invite Mr. John Brooks, please, to come to witness table? I don't know if is the microphone turned off or is it on, Mr. Brooks? If you can press the large button in the middle, it should light red. You've got it.
That's it, yeah.
Are
Can you hear me?
Yeah, I've got it. Yeah. I assume you're adopting the same position as Mr. Graves in terms of.
I am very, very similar, but being the chairman of the lake, I obviously have to deal with the fishing side of things and I have to deal with the community that walk around there all day because they speak to me every day. So I get to see the environmental impact because we do tests on the water in the lake, okay? Not so much the river, but it's the river that's the major issue for Brackley at the moment.
Okay.
So I've just got a short statement because obviously you've got the information from the club now. So I've just got a statement that's on behalf of the fishing club and most of the
If you
community.
can, you don't have to do, but if you can let me have a copy of that statement, that would be helpful.
Yeah. Cool. Yeah.
Thank you.
Do you want it electronically, do you?
Sorry?
Just tell it. Do I just email it to you, can I?
You can email it or you can give me it as a document. You can give me that copy and I'll get the council to put it on the website. It's entirely your choice.
Yeah,
You don't have to do it all. It's just telling me
No.
that I've got a formal record of it. That's all.
Okay, yeah.
So when you're ready.
Okay, right. Well, like I say, this is just a review of what I am hearing as chairman of Brackley District Angling Club. First of all, thanks for allowing me to speak today. I am the chairman of Brackley District Angling Club, and after being told of the plans to build the 700 new houses on fields next to the rugby club, our members and some of the community do have concerns about this going ahead. We believe that building these houses will effectively overwhelm the river system and Brackley Lake, which in turn will devastate the natural ecology of this part of Brackley. The River Ouse that runs behind St James's Lake is in a poor state of repairs. There has been no maintenance on this stretch of the river and now it has large trees and foliage blocking the natural flow of the water. Photos have been handed out. The flooding of the river at St James's Lake have continued to worsen over the past 10 years. The lake lays at the lowest part of Brackley and the water table at this site stays fairly static during the summer months. It has 4 natural springs that run into it continuously. We are now finding that the river and the lake are continuously flooding during the winter autumn, winter, and the spring. The river not only takes on many springs that run into it from the Brackley side, but also the springs that run off the farmer's field adjacent to a dual carriageway. This in turn makes the water flow dark brown from mud being washed down off the fields. This then helps to block the rivers and also ends up in the lake, which when built, the lake was not supposed to take water from the river. It should overflow from the lake to the river as angler water is concerned. The lake was built in 1976 from two smaller ponds and was classed as a balancing lake. But in 1976, there were marsh grounds all along the Great Ouse, through Brackley and beyond. But now this marsh ground has had to make way for development over the years, and this in turn is adding pressure to the river. The lake and any floodwaters now have nowhere to go. As the river and lake are at the lowest part of Brackley, we believe these new houses will only add to the volume of water in the river system via natural springs and watercourse feeds. That possibly coming from the site, it is stated that some basins are being proposed on this site, but not all basins work. There were basins built on the top site behind the BP garage at Brackley, but these basins have never had water in them. They're just filled with trees and bushes. The ground around St James's Lake is constantly wet and very boggy, so much so you can't walk on parts of it. The proposed fields on the planning are also constantly soaked and have streams that run off them, which have now caused many large gullies, some probably about a foot deep, which all run down towards the river. Also, the houses adjacent to the fields have had to have ditches dug out to stop them from flooding. We believe this excess water will eventually make its way to the river and lake. We also believe that the constant flooding of the river system in Brackley is not only eroding the banks of the river, but also the lake. We are in a constant battle to stop the eroding around the lake, which we are responsible for. We also believe nature itself is now being affected with the flooding, as the kingfishers, moorhens, ducks, and all their nests are constantly being destroyed by the flooding. We also have seen the demise of insects in the river, including dragonflies, damselflies, mayflies, plus many more species that lay their eggs in the lake, which in turn fed the fish, the birds, etc. These insects are an important bioindicator of the water, and their presence reflects the health of the river and the lake. The lake poster on the estate states that there are snakes, water voles, and many other animals that reside at the lakeside. There is no proof now of any of these animals existing. These include water vole and grass snakes, adders, etc. We also believe that the river has a nitrate. Just bear me 1 second. Yeah, we also believe that the river has a nitrate issue from the farmer's fields after a flood. We are sure this river water should not be allowed to flood back into the lake, as stated by Angling Water. To sum up, we as a club believe if the building of these houses goes ahead, it will add to the water volume in the river and lake, causing major flooding all along the River Ouse, affecting houses, businesses. So we believe a smarter way to store or disperse the excess water from this site should be found instead of basins. Also, before any new development is approved, we should be looking at the river system first throughout Brackley, as it did its job for hundreds of years and now we've pushed it too far. And more importantly, before we have a major flood issue with all the buildings that run along the river bank.
Thank you for your contribution, Mr. Brooks. I think you've heard that we are taking this matter seriously in the inquiry, so we will get some further information and I will have a look at it on Thursday.
Okay, well, like I said, as my colleague said, you've got all information, so I just wanted to add what the local community and obviously the fishing club can see physically.
Yep.
So, yeah.
Thank you for your contribution.
That's okay,
Thank you.
I'll turn this off.
You can leave it on because the next witness will only have to put it back on, so it's not a problem. Can I invite Alan Mays, please, from the CPRE? This your speaking note, Mr. Mays. Thank you very much indeed. I'll record the speaking note as ID 4. So it's a speaking note of Mr. Mays. Just bear 1 second, Mr. Mays. Thank you for your note.
Thank you.
Before you commence, if you can just explain your position, who you represent.
Yes.
Even though Mr. White probably won't ask you questions, I'm going to ask you if you're prepared to answer questions anyway, if he did ask you questions,
Yes.
which you are.
Thank
So
you.
if you can just explain who you are, who you represent, your position in the application, then please give us your thoughts.
Thank you very much. Thank you. My name is Alan Mays. I'm the Honorary Technical Secretary for the Northamptonshire branch of the Campaign to Protect Rural England, CPRE, and a trustee of that organisation. I'm speaking today on behalf of CPRE Northamptonshire. CPRE believes that this appeal should be dismissed. We do so because we believe strongly in the principle of plan-led system that secures sustainable and well-located growth through public consultation and democratic choice. This proposal for around 700 homes lies wholly outside the settlement confines of Brackley on open greenfield land to the west of the town. It has not been adopted for development in the strategic or local plan. The existing spatial framework for West Northamptonshire is set by the Joint Core Strategy of 2014 and the South Northamptonshire Part 2 Local Plan of 2020. Both direct major growth to Brackley's existing strategic sites and require other development to remain within confined boundaries unless expressly supported by policy. That policy approach has now been carried forward and reaffirmed in the new Regulation 18 West Northamptonshire Local Plan, Draft Local Plan, published in April 2024. Policy S1 of that draft plan confirms that future housing will be concentrated in Northampton and Daventry, and that within the rural service centres of Brackley and Towcester, the emphasis will be on existing planned growth, together with regeneration within the urban areas. Only one new location is identified for Brackley at Brackley East, and none to the west where the appeal site lies. In other words, the emerging plan makes clear that Brackley has already expanded to an appropriate extent and that further peripheral growth will be unsustainable. To approve this scheme now would be premature and would seriously undermine the integrity of the new local plan process that is already underway. CPRE considers that the site to form part of the distinct open countryside that defines the western edge of Brackley. The existing housing along Hulse Road already makes a clear and logical settlement edge. Extending the built form beyond that line would erode the transition from the town to the countryside, contrary to both national policy and emerging local plans on landscape protection. Paragraph 135 of the National Planning Policy Framework requires that decisions ensure developments are sympathetic to local character, history and landscape setting. The proposed development fails that test. It would replace open farmland with a large urban extension of no strategic need and no defined infrastructure framework. West Northamptonshire Council has maintained a 5-year housing land supply and has sufficient commitments to meet its objectively assessed need. Any further housing requirement arising from national policy changes should be properly met through the plan-led process, not through ad hoc speculative applications such as this. We recognise that the scheme offers affordable housing and other facilities, but without infrastructure planning and community engagement with that a plan allocation would ensure, these benefits cannot justify the harm to the open countryside and undermining local plan policy. CPRE nationally has carried out recently research that indicates that 1.4 million homes could be built on brownfield land, and therefore government targets could be met without the need to sacrifice yet more greenfield sites to these aspirations. For all these reasons, CPRE Northamptonshire respectfully urges the inspector to dismiss this appeal. Doing so would uphold the principle of a plan-led system, protect the character of the countryside around Brackley, and preserve public confidence in the local plan process. Thank you.
Thank you, Mr. Mays. I know you've said you won't, but I will offer you the opportunity. Do you wish to ask any questions of Mr. Mays? In which case, thank you, Mr. Mays. And if we can ensure that your document is placed on the inquiry website, we appreciate it. Thank you for your contribution.
Thank you.
The last person that I have on my list now is Kevin Blanco. Have I said that right? Thank you. If I can invite you to come to the witness table, Mr. Blanco. Same things I'm going to ask. If you can explain your position on this application. If you have a speaking note, you can either give me it, you can send it in, or you don't have to bother. It's entirely your choice, but I will make some notes today. Depending on what you say, might depend in which advocate I look at in terms of any questions. But I'll bet that decision when you've told me who you are, what you represent, and what your position is. So please commence.
Yes, good afternoon, sir. Good afternoon, everybody else. I haven't addressed the council chamber for a while, but I do have experience as elected representative in Cambridge and do have a fair bit of planning experience on the back of that. I came here today, I'm speaking in an individual capacity as someone who's born in Brackley 62 years ago, left at 18, and I've recently returned. So I have fair knowledge of Brackley as a town and how it's developed and changed over the years. It's not changed as much as other similar sized towns over the years, but it has changed obviously to a degree. But the reason I'm here today is actually to show some support for this development. I read an email, I won't say who from, that suggested everybody was opposed to this development. Well, that's a complete nonsense. People in my family have known about this proposal for many years. It's been mooted for quite a while. This side of Brackley has been extended several times previously, and this has been obviously on the cards for quite a few years already. And it sounds like from what I've heard so far this morning, that both sides here actually in favour, in principle, of the development. And from what I can understand it, there's an issue here of the council safeguarding its positions in terms of policies and future regard to developments in the South North area, which they have to maintain on the back of this appeal. Maybe I've misread that, but that's the way I've understood it this morning. But my view is that, this is again speaking personally, that Brackley, yes, has had development in recent years. The Poppy Fields estate being the most recent, and on the whole, I've toured it extensively. I think design-wise, it's a pretty good development. There are clearly issues with the main road through it in terms of adoption of by the highways and how they deal with inappropriate parking on that main route through. I'm sure at some point in the West Northampton highways, people will resolve that problem with hopefully with some sort of haste anyway. But in terms of Brackley itself, at the moment, I can only see, again, this is from a planning viewpoint, how Brackley can develop. They can only develop in a westerly direction. We're hemmed in by HS2 at the top end, the A43 on the eastern side. I think the area around Hinton that's on the south side of Banbury Road, the old Banbury Road, that's not really ideal for any sort of residential development in terms of the farmland importance there and the actual issues of runoff and geography of that site. So the west side of Brackley is probably the only logical extension site that we can foresee. Clearly, 700 homes in the context of Brackley is a big development, and some people are concerned how that will integrate with their own streets, particularly the people who live backing onto these fields at the moment. But I think these days, with understanding of pedestrian and permeability, the access sort of ways that can be made through these sites without vehicles having opportunity to come through them, is the way forward. I think if people on the edge of these fields at the moment are brought into the conversation and that only cycling and walking routes can go through their small streets, then I think they will be comforted. Clearly, there are points of access on Holst Road and on the existing Banbury Road at the existing roundabout along it. Again, I think the highways have maintained that they can deal with these matters, and there's no opposition from the highways department. Picking up on where we are, there doesn't seem to be any opposition from the environmental assessment teams. They've looked at the EIA and they haven't found any real major issues with that. Highways don't seem to have an objection, and I think overall, I think West Northampton seem content in principle for this development to go ahead. Clearly, down the line, residents will like to see the detail, type of housing, and all the different sort of component parts of a planned development site. And I hope applicants will engage with the public in a far better way than I think has been done in the past. And I'm not being overly critical. I think it's a case where if you want people to engage with the planning process, you need to go out and about and bring them into it. It's surprising how few people are here today for this planning appeal. If this was in Cambridge, this gallery would be full. And that was often the case for applications up there. The engagement needs to be, I think, improved. That's not an easy thing to do at this, without a good sort of programme to sort of assist it. But I think that's something to look at. But anyway, for me, the point of the 700 homes in extension in Brackley, I mean, there's a huge national conversation, as Mr. White referred to, going on at the moment. I think from experience, some of the projections are aspirational rather than perhaps wholly achievable, but we'll see. I mean, I think the actual conversation needs to be had because there is a lack of housing. There is an urgent lack of social housing across the country, and Brackley's Brackley is a component part of the county and the country as a whole, and other smaller towns have to play their part, I think, in meeting this shortfall. As I said, I think issues of housing mix will come down the line later, but I'm surprised we haven't had, unless I've missed it, there's not been a formal submission from the town council, and there's no town councillors here speaking today. I'm surprised at that, in that this is going to have a big impact on Brackley, and I would have thought the town council would have had a shopping list of actually what they would like to see in return for this development and how it improves the town and the area around this site. Clearly, the rugby club will benefit, and there'll be more allotment space, and there'll be public open space always throw in the idea of what we abbreviate as a mugger, a multi-use games area, for those who aren't familiar with that. That's something Brackley is lacking for youngsters in the winter months particularly. We have basketball courts and a few sort of facilities that of that regard, but muggers are quite successful in certainly in suburban settings, and I think that may be something to consider. But I say a lot of the open space details, the public space, play space details will come in with the detailed application, should that be coming down the line at a later date. In terms of the section 106, which is clearly the point of this appeal, it's what the council held out as the reason for refusal. Again, I'm surprised the town council haven't come with a shopping list of what they would like to see provided on the back of this development, and West Northants may step in to help them in that regard, and I'm sure they will. In the decision notice, there is talk of figures for educational components, primary, secondary, early years, SEND, which again is a major issue in this area as it is across the country. These contributions need to be hammered out and actually brought into the benefit of the Brackley community. I think with good faith on both parts, I'm sure that can be done, and I think that needs to be done. One of the previous speakers talked about primary education. Well, again, I've sort of sat and watched what's been going on in the last 3 or 4 years in Brackley. A primary school closed, yet there was still in the offing a 700 home development on this site and a 350 home development on the Tweston Road. It seemed a bit short-sighted to me. I didn't really get involved in that campaign, but a lot of people did, trying to save the school, both for those who were present at the time when it closed and also for the future of Brackley. And I think you've got an educational resource there which needs a projected use, whether it be a community use, educational use, or whatever, but it needs to be kept in a use that's going to benefit the town. But Southfield, the reason I mentioned Southfield School is on Banbury Road. Your access is off Banbury Road. It's within, well, for many youngsters, probably is within walking distance, and certainly cycling distance, although not many people cycle in Brackley compared to Cambridge, but that could be enhanced perhaps. But I say that's a point to be considered. I think I've covered most of the points I wanted to make, but I think the crux of my point is I think Brackley can only expand westwards. I think in a geographic situation, that's the logical sort of side of the town that will develop. And I think we also bring in the context for the need. I mean, people in there, I don't want to be offensive to people, but people who have comfortable homes at the moment should be aware that some of these future residents may not at this present moment in time. There is a lot of business and employment cropping up around Brackley. I came on the bus through Silverstone. There's a huge business park at Silverstone, and where these people who work there when the units are fully let are going to live is an interesting point. But I mean, some of them will certainly live in Brackley, I'm sure, as they do as people who work in Milton Keynes, Northampton, Oxford, and the biggest employment areas around Brackley do at the moment. Yes, that creates a bit of a commuter dormitory issue, but actually they're still part of the community. They come home after work, they spend their money in Brackley, they enjoy their leisure time in Brackley, and I think 700 homes can be accommodated and will actually be a benefit to Brackley. I think that's probably enough. We used to get time limited in Cambridge, but obviously this is a bit different. But and I'll just pick up on the point, if I may. I don't wish to concentrate on and what other people have said, but steal their thunder. But the people from the Angling Club are quite right in what they describe as a problem. There is I call it a stream rather than a river behind St James's Lake, and you may wish to have a nice walk around St James's Lake on Thursday. One of the best leisure points in Brackley. But that stream has been left neglected for many, many years. It's become overgrown, as the chap said. There's tree trunks in it. It's been subject for fly tipping incidents, and it needs care and attention. And if the drainage officers of the council do think that would be an advantage on the back of this application, then look at it. But I think it's something that should be done anyway. There needs to be some work done on that stream. Some argue that stream is one of the beginnings of the Great Ouse. It's debatable because others think it's from Cyrisham. But actually it is a stream that does act as an overflow to St James's Lake, and clearly if it's clogged up, it pushes back the water into the lake, which you may see. But I call it a stream. We used to, when we were children, we were in there with our bare feet, picking up sticklebacks and minnows in a net. That's a stream. That's not a river in my description, but you can have a look for yourself. Yes, I think they picked up on a point that Brackley needs to resolve. That stream does flow through the back of Tesco's, causes them problems. It flows through the site that's abuts the Petronas site. Again, major employer, Petronas, growing quite considerably. They've just built a new multi-storey car park to accommodate their staff next to the football club. Football club in a great position at the moment. National League, FA Cup on Saturday on the TV. But I mean, Brackley is changing. It's growing.
Thank you for your contribution. Appreciate that. Just before you leave, I would normally turn to the councillor, but I don't think I can. I don't think I can at all.
No.
Not that you probably wouldn't have any questions.
I wouldn't have had any questions in any event, but no.
No. In which case, can I thank you for your contribution? You don't have to send in. I've made copious notes of what you said there. So you don't have to send in anything in terms of an inquiry document. I've got a note.
I'm not sure I remember what I've just said anyway, sir, but
don't worry about it.
I think you get the general gist.
I've got the general gist completely. Thank you for your contribution. If you can turn the microphone off, that would be appreciated, because that would close we're getting towards the close of this morning's session. All right. Can I thank the people who've made contributions today? Certainly one of them just thrown up a little bit of work. Just what's going to happen now, we're going to take a break for lunch in a few moments. Just before I do that, just in terms of housekeeping matters for this afternoon, I'll probably do it after we've done the roundtable session. I'm aware there's two things that I asked for. One's a simple one, which is an A3 copy of the Scott schedule attached to the Statement of Common Ground and Housing, only because it helps my eyes tomorrow, nothing more than that. So you can give me that, and I won't record that as an inquiry document before we leave. There's nothing contentious in that, Mr. White. It's just me saying, give me a bigger version of that, because when I look at it in sunlight, I strain my eyes a little bit. So we'll use that for tomorrow. The second thing was, and I know I've got something that's come through. I did mention about you having a look at the suggested agenda for tomorrow's roundtable session. I've not read what's come through yet. I haven't had the opportunity to do, which I will do at lunchtime. But at the end of the roundtable session today, I will just ask respective positions on that, and then make a determination as to whether or not I'm going to get an agreed agenda, or whether I need to form an agenda of my own, which I would do. But in this case, I thought it might be better for you to have a bash at it. You can do some hard work on it. That's the reason why I did it. And sometimes in PINs, there is a drive for us to do that more, to say, well, rather than you do it, inspector, get the parties to work on your behalf harder. But we'll have that discussion. So it's just I don't want to do it now, just to say that this afternoon, I will finish by saying, right, where are we with that agenda? What do I need to do? But I'll come to that conclusion a little bit when I've read what's just been submitted. Unless you want to say anything now. It's probably better not. Let me read it. Yep, let me read it. All right, it's just about 1:45. Would a 45-minute lunch break be okay to parties? Or do you want to know? Quarter to.
We've all got to go out. History often says that when you've got to go out, they're quite large.
Yep, no problem.
Quicker,
Yep.
potentially.
Yep, not a problem. It's 12:45. We can resume at 13:45. So we'll adjourn at that point there. At 13:45, we'll resume with the roundtable session. The people who've spoken today, if they want to sit round the table, what I will ask is if just the council keep the people who need to be here around the table and the appellant. And if you want to join us around the table, by all means, please do so. Might even pull another table in, but it's a roundtable session, so people who've spoken today can join us if they want to do. I'm going to go through the conditions sequentially. We'll start with those. There's no agenda for today. It's pointless. And then we'll go through the plan obligation. Similar, I'll just ask the parties to lead on that, just take us through it. I have very few questions on that, if I'm being honest with you. So I'm just want to touch on it, see if there's any issues arising.
I think you indicated, perhaps I misheard, but I think you indicated you had some reservations about one or two of the conditions.
Yes.
I wonder if you might, not without saying anything in detail, but just identify which those are so that we could.
So ones that relate to the granting of licenses before development commences, things that are not within control of the planning authority, which I'm wondering if they are properly constructed planning conditions in the context of the guidance of the PPG and the NPPF. So it's those that relates to badgers, it's those that relates to newts, because they were not within the gift of the planning authority. And I'm not so sure whether those conditions are justifiable planning conditions. There's a couple of the minor points which I think are rectifiable, that there's a couple that lack an implementation clause, etc. But the ones that give me concern are the ones, and I probably know where they've come from, and I probably know why you've stuck them in there. But the ones that I don't think are planning conditions, I think the granting of a license that's not granted by the planning authority is within not within your gift. And if they didn't have the license in any event, they'd be committing an offence. So it's those conditions that I'm struggling to think about. They've probably come from the council's ecology department. But I struggle a little bit with those conditions. So those are the ones that I think I want you to just have a look at.
Thank you. That's very helpful. So it gives us a bit of a heads up.
That's okay. All right. 12:47. We'll break at that point. Back in this room at 13:45, and we'll commence roundtable session. So at that point, we're now adjourned. Thank you. All right, it's 1:45. The inquiry is now resumed. Before we get into the roundtable session, there's just a couple of housekeeping things I just want to go through. When we do the roundtable session, if people want to join us, if they want to participate, they can. If you want to sit at the back and observe, that's fine also. It's entirely your choice, but I'll come on to that in a moment. Just in case, in terms of housekeeping, and then I'll talk a bit about what we're going to do this afternoon. I've received the revised SIL compliance statement. Are you going to give me a hard copy of the revised one or the previous one?
I have a revised copy, sir, of the updated version.
Then the updated version, I'll give it an inquiry number
Okay,
because it supersedes the previous one.
Okay.
So I'll give that ID 5 is the updated SIL compliance statement. I don't need it now. You can give me it. We'll take a break after the conditions. I've also received the dummy Zoom invite. So after we've closed today, I'll have a bash at logging onto that with whoever it is from the council present, just to see if we can see each other.
Yep.
So I've got the codes for that. So I'll see if we can do it. And then if not, well, Tim and yourselves will have to find a contingency, but I'm optimistic we will be able to do that, but we'll try it. The final thing of housekeeping from me, I've seen the respective comments on the agenda for tomorrow. I don't think we need any discussion. I'll cobble together an agenda tomorrow. I'll send that to Tim this evening. He'll probably send it to the parties tomorrow morning. If you can bring some hard copies of that, just a couple for anybody who might want to participate in those discussions. That's that one. Was there anything else I wanted to say? I don't think in terms of housekeeping, anything else has arisen over lunchtime. Anything from you, Mr. White?
No, thank you, sir.
Mr. Fraser-Quart, anything from yourself, housekeeping matters?
Yes, I think we are arranging for Councillor Baker's hard copy remarks to be circulated. I think it's being printed now, I'm told. So
It's
we'll-
okay. You can give me those later.
we'll keep you in suspense and
All
pass
right.
that on a bit later.
All right, what we're going to do with it then now, we're going to come into round table session. Advocates, it's entirely your choice whether you sit there or you get a coffee, whatever you want to do. I don't usually expect input into these matters from advocates, if I'm being quite honest, but it's your choice. I'm going to go through the conditions first of all, sequentially. We're going to go through each one. I'm going to ask you to bear in mind the tests of conditions. You know that, I'm not teaching you to suck eggs. There's a couple where I've got comments and it'll be quite plain when I say that. Some of them are very minor. Some of them are thinking, not so sure this is section 278 or this is a planning condition, for example. And there's a couple where they're lacking some clause and there's some clumsy conditions, if I'm being quite honest, that I think have come from consultees and just dropped in verbatim. And as a consequence, they've not had a kind of a plan in mind, think through them, I think, but you'll tell me if I'm wrong when we get to that point. When I've done that, we'll take a break. We'll resume then with the obligation. I've got very few comments on the obligation from a drafting perspective. What I'm going to do, because there's interested parties observing or I might be participating, I'll ask you to take us through a couple of points through there. My comments are fairly minor. And I will warn you, the only comment that I've kind of picked up, which I've kind of a bit of a new one to me, is naming the role of a person within the local authority within the agreement. So the executive director of economy and place, for example, or the replacement person. And I'm just wondering whether or not, is that not just the council, or does that person specifically need to be named? And what happens if that role disappears completely and it moves to somewhere else or is outsourced, wherever? How does that fit in terms of giving approvals? So that's perhaps my only major comment. Nothing more than that, because it's your agreement, you've agreed it. There's nothing in there when I've read through it that jumps out at me other than that, thinking, oh, I'm not so sure about that one. And I think there was something else that's a minor interpretation thing as well, but nothing. But we'll ask you to go through it so we all understand what it's done. And I'll probably, for the avoidance of, or to give you both a chance to perhaps participate, I'll ask you to take us through certain sections, I'll ask you to take us through certain sections, only for variation and nothing more than that. All right, if you do want to join us and participate in discussions, you can either sit at the bottom of the table there or come sit at the witness table and pull a chair up. If you're happy just to listen, that's fine. So it's if you want to move up, move up. If you want to stop there, stop there. But if you're going to do it now. It's whether you feel you want to contribute. It's whether you feel you want to contribute. I'm not going to deny you the opportunity to participate if you wish to. Some of it is going to go over your head, and I do apologise for that. So you just pull your chairs up. If you want to use that table, that's fine. Brilliant. Now that's a lot more cosy. All right. I bet there's not a spare. I'm just thinking, is there not a spare copy of those? Is there that we could just leave for the gentleman at the back?
Sorry, I don't have one to hand.
Could we just get one?
I could nip out and. Oh, you've got okay.
If you've got one, just so that you know what we're looking at, because otherwise it is going to go way over here because you can't relate it to anything. They are online, but I notice it. We're not going to do that. But so there you are. So I'm going to go through those conditions individually. The first condition, unless anybody tells me otherwise, it's a straightforward condition that I would expect to see. So I don't have any comments on condition 1. Nothing from either party? Easy. Condition 2 is a straightforward standard condition I would expect to see. No comments. Condition 3 is the plans. I did ask you to check this morning that we've got the right revision numbers and the right plan numbers. As that condition is drafted before me, do we have those right numbers?
Yeah, we're happy, and I've spoke to Mr. Callis that we're happy that they're the correct ones.
So all condition number 3 is setting out the plans that's been submitted that are what the appellant is seeking approval on today. Yep.
Apologies for not having these plans in front of me, but in terms of the proposed non-motorised road user improvements on Banbury Road, could someone give me a gist of what that is?
Do you have a plan, spare plan?
Is it cycle and pedestrian improvements? Is that the gist of it?
It's a connection from the top of the site to an existing cycleway. Or is it the south one? Sorry, it's a southern connection point from the roundabout, and it's a cycleway footway running along Banbury Road.
Yep. Yeah. There is a plan that shows that.
Yeah. Thank you.
Yes, it's just this red essentially showing the pedestrian connection to bus stops and into.
All right. I can't have any discussion on that because that's what's been considered and submitted. So it is what it is, I'm afraid. Condition 4 is asking for a phasing plan. That's understandable. So we understand what's being proposed and when. I don't have an issue with oh, just a moment. Just on that phasing plan, is its intention just to show phases or is it intention to show sequence? Because as it's worded, it doesn't show sequence.
They will be numbered. We would usually number them as phase 1.
And would you expect development to proceed sequentially?
We'll start at both ends of the site and work inwards.
But so right. So although the numbered phases, it doesn't mean to say you're going to do 1, 2, 3, 4, 5. It could be 1, 7.
we would number them, so 1, 2, 3, 4, 5, if that makes sense. So they would be sequential.
Right. The condition is just identifying a phasing plan. It's not identifying what sequence of events that phasing shall occur, from what I read. Are you wanting that? Are you just wanting a phasing plan? Are you wanting to understand when they're doing phase 1, phase 2, 3, phase 3, phase 4?
I think so. From the council's perspective, it's to understand how the site sort of goes. It's in sequence. It's not that it's yeah. It's just to understand, because the site's got 2 road frontages.
Yep.
Just to understand how that is built out, because it isn't most likely going to be from the south working north. It will be a
Yep.
mixture of both. So it's just a.
I'm not going to comment too much then, but I'm going to ask you to have a think about that condition as it's worded then. Because I can interpret that as all you require is a phasing plan that shows phases 1 to 7 and nothing more. It doesn't say when you're going to do phase 7 or when you're going to do phase 1 and whether you're going to do phase 3 or do you start in the middle. So what you're saying to me is something different to what the condition says, I think. It can be interpreted as just a phasing plan. It doesn't mean they've got to stick to it. Doesn't mean to say they've got to do it sequentially. All you want to plan is saying, I can break it up into 20 phases. But it's meaningless unless you want to do something more with that. So have a think about it.
Thank
What
you.
I'm going to do, I'll give you 2 weeks to have a think about those conditions again after today, because there will be modifications. But as I read number 4, it's not what you're wanting, I don't think. All right. Question 5. Condition 5. That's a straightforward statement. No more than 700 dwellings, full stop. There's not much more I can say on that one. The 6 and 7 are about ensuring the access points are put in there, effectively their entirety, until the works to create those access points as shown on the submitted drawings have been implemented, and that those highways then are open to traffic. That seems to me sensible condition. There's nothing in its drafting that I've got a problem with in that condition. You okay with that? So all that's doing is saying, right, before you occupy any dwellings, those highway access works have got to be completed and open to traffic. So you can't have something in a half-built thing that's starting to get access for occupation. And southern access, well, the southern access is prior to the occupation of the 125th dwelling, where it's to create the southern access in accordance, because that's because I assume the northern access is going to do the first phase.
Yes,
So
correct.
you need to think about that then in relation to condition 4. All right, condition 8 is site clearance. Avoiding the bird nesting season, that's perfectly understandable. I don't think that should be a contentious condition for anybody. It's saying don't clear trees and shrubs when it's bird nesting season. Okay. Condition 9. Why do I keep on question 9? It's probably because we do a quiz in the working men's club on a Sunday night. Guess where I was Sunday night?
You didn't say condition 7.
No, but I did inadvertently give the answer out for one of them, but that's another story. Because I didn't know what the answer was and actually gave the answer. But anyway. 7, ecological survey. The development hereby permitted shall be carried out in accordance with the recommendation mitigation measures and enhancements identified in Chapter 8, Ecology and Conservation. Yeah, that's fine. Addendum. And the sport appendices, unless otherwise. I don't have a problem with that. That's just saying that the ecological the development shall be carried out in all the ecological things that's in the environmental statement. That's pretty straightforward to me. Ecology check. Prior to and within 12 months of the commencement of the development, the site shall be thoroughly checked by a suitably qualified ecologist to ensure no protected trees that could be identified by the development sorry, most protected species which could be moved onto the site. Since the previous surveys are carried out, should any protected species be found during this check, full detailed mitigation measures to prevent their harm shall be submitted to approved in writing by the local planning authority. That's doing another SENS check, a survey on site to ensure that there's no protected species that's moved on since all the information that was submitted in the environmental statement. You wanted to say something?
Yeah, can I just ask, has any like ecologist reports already been done prior to it?
Yep.
Have they been done?
Yep.
Is there anything that's been printed and
That
tell us?
all of those they're in the core documents that I mentioned this morning. The condition identifies which the condition above, number 9, identifies what parts of the environmental statement and addendum where that information can be found. So that it has all been done.
It's been done.
It's been
Okay.
done.
And another one will be done prior to the building.
That's what
yeah?
this is saying.
Okay.
Prior to and within 12 months of commencement.
Okay. Yeah.
So they're doing it twice effectively, to check that there's no protected species moved on. Condition number 11 is the one that I have a bit of an issue with. And it's just whether or not it passes the test of a condition. And the reason why I say that is because this is saying that you can't commence until you've got a license effectively. But you can't commence in law until you've got a license anyway. Or you probably can commence, but you can't breach the license, otherwise it's an offence. And for me, it's wondering to what extent of control is that a land use planning condition, or is it something that's absolutely relevant to the legislation, which runs in dovetail to this development?
Okay, if I could perhaps just explain, sir, so condition 11 relates to Great Crested Newts and the council's district licence that it has with an organisation called Nature Space, which is an approved operator on behalf of Natural England.
Yep.
So it's a formalised arrangement whereby the council has a licence with Nature Space, and then developers have the opportunity to utilise that licence in order to mitigate any impact on Great Crested Newts. And one of the terms of that licence is that the council has to include in planning permissions the verbatim, the conditions as they're set out in the report that we receive from Nature Space, which the applicant provides. And that's what we have at conditions 11 and 13. So essentially the council is just seeking to accord with the terms of that district licence.
So what you're expecting the development to proceed in accordance with the information submitted to support that licence application? All
yes,
right.
Yes. I haven't had a huge amount of experience with the district licensing scheme, but
right. That's different. I could accept that, because then you're approving a scheme of something. What I didn't want you to be approving is the fact that there's a license in place, because
yes,
what I'm really thinking then is the way to get around that, in my thoughts, and you need to think about this from a test of conditions, is that the information to demonstrate mitigation measure in place, whether it be a new habitat, translocation, wherever it might be, you have a scheme for that. Just happens that that scheme is the same scheme that the licensing authority will make that license decision as well. And then you can control the implementation of that scheme through planning. In addition, they control it through the license, I suspect.
yes.
And I'm more thinking of it's easier for me to deal with it in those terms for the scheme to be submitted, as opposed for you to kind of demonstrate the license is being granted, because you could say that for everything. Go on.
Sorry, sir, if I may, as I understand, and again, I'm not an expert, as I understand though, the licence exists under the district licence scheme. So effectively, the appellants are applying to use that licence. So we've submitted all of the information to use that licence, and essentially license already exists. We haven't got to get a license. It's to
Yeah.
use the license under the district licensing scheme. But I can see your point about how we word that.
Yeah, what you've said there is not a planning condition in my thinking. Have a think about it. I think you can get round it by having the scheme that demonstrates it, because somebody's got to control that there's surveys, that there's mitigation, that there's translocation, there's habitat creation if need be. But the license would do that. So what would you do beyond the license is what I'm kind of thinking about. Because as I say, in other words, you have licenses for lots and lots and lots of things that don't come into the planning arena.
Yes, I mean, all I can say is that what is in here is what we've been sort of directed to include by Nature Space.
Absolutely. And I often say this in lots of other forums, you're the planning authority.
Hmm.
Lots of local, I sit in these forums many times and I think, why have you put that on there? Oh, we've done it because so-and-so wanted it. Well, they're not the planning authority. You are. They're not bound by meeting the tests of the conditions in the PPG and the NPPF. You are. So why just accept it? You should be integrated. So that's not a justifiable condition. Think of a different way of getting around it to make it a justifiable condition. And that's what I'm saying to you. I understand why you want it. I can understand why it might be in some ways better for you to control it through the planning enforcement. Because if they breach the license, who enforces it? You don't. The licensing people do. So you could argue then it's not an enforceable condition by the planning authority because somebody else has got to enforce it. I've said what I need to say. All right. The drainage strategy. I don't have a problem with this, but I do have a problem with its interpretation at the end. All subsequent reserve matters applications for each phase and subphase shall be accompanied by an updated drainage strategy. It comes back into what there's another condition relating to this. That's fine. Development shall be implemented in accordance with the originally approved drainage strategy or the subsequently updated strategy as approved. It's the word or. Could you do either? So I can do the first one, but I've updated it, but I've got an or in here. I can do that one or I can do the other one. It's really as except as modified by the new one. So you want the previous one implemented, except as modified by the new one, because I could interpret the wording of that as giving me an option. I can do that one or I can do the new one, because I've got an or, your choice. It's just a drafting issue, I think. All right. Yep.
Don't they use the phrase sustainable drainage these days to be slightly more involved than just a standard drainage strategy?
I'll ask the appellant to comment, but you could argue the drainage scheme is designed on sustainable drainage means, but do you want to explain?
Yeah, so I think in designing a drainage strategy that could accommodate, we could be looking at sort of foul and or surface water. So, but we are required to design a scheme that would be sustainable urban drainage in any event. So whilst the use of the word's not necessarily an issue, it's written into legislation essentially that we have to design to those standards.
Yep.
Can I just ask, is there a copy of this drawing number 5028761? Is there a copy here?
There will be.
Again, it's on the core documents, so it'll be online.
But you'll be able to look, everything that's in here that's got a document reference, the document is available to look at. All right, let's look at 13 then. So there's a bit of work on 12, I think, just to be clear about what you're thinking there. 13 comes back into probably the previous discussion we had a little bit. So you're wanting a certificate from a delivery partner, and it's really pursuant to the license. Who gets that delivery certificate? Is it part of the license requirements? I'm struggling again with this one because it seems like you're trying to enforce a regime of somebody else, so it's got its own enforcement regime anyway. Do you want to have a think about it? I'm not going to put you on the
If you can,
spot.
sir, please. Yeah,
It's the
thank you.
same, it's the same issue that I'm thinking this is a licensing matter, not a planning matter. And how do you know if that's a justifiable delivery partner? Because the licensing people are going to only do it if it's a justifiable delivery partner, not you. So it seems to me that that's not enforceable under planning. It's enforceable under, well, whatever it is, a Wildlife and Countryside Act, I assume, or something, but it's not a planning condition. And that's what I'm struggling with.
I think so. If you're happy, we'll take these away.
Gets the ecological people off their back. And then you get a clever dick like me in a forum like this, where saying, well, hang on, I mean, that's not right. Otherwise, it would never get challenged. But I've got to think about, is it a valid planning condition in the tests? All right. Why? No development on the relevant phase or subphase shall be taken with the areas of archaeological interest until the applicant or their agent or their successor in title. Well, you don't need any of that, because what you're wanting is a scheme of archaeological work in accordance with the scheme investigation. And then the next bit, which has been submitted by the applicant and approved in writing, not the applicant or the agents or successor in title, as the previous bit says, you don't need any of that. All you're wanting is a scheme of archaeological investigation submitted for approval. And then the next part, the written scheme shall include the following components. Completion of each will trigger the phase discharging of the condition. Right, I'm not so sure what that means. I suppose it means that each of those 4 points down there will have their own separate discharging as opposed to coming in as a whole. I'm not so sure if that's what you want. But I don't understand the first one. Approval of a written scheme of investigation. So the scheme shall include the approval of written scheme of investigation. How do you do that then? Because you haven't even got it. So it's clumsy, if you see what I mean. You can see why I mean that. All you're wanting is a written scheme of investigation. Field work in accordance, and the scheme shall identify the field work. Completion of post, and that's the next one I just can't get my head around. Completion of a post-excavation assessment report, I can understand that. And approval of an updated project design. What does that mean? Does that mean the layout? Does it mean the whole development? Does it just mean the archaeological project? What on earth is that? I'll leave you to it. Could say discuss. But I don't know what that means. I don't know what you're expecting. I ain't got a clue what you mean by an updated project design. But it's not right, is it? You all you want to know is how was that evaluation affected the development? And you need something to show that you've taken it into account, either by securing measures of, I don't know, investigation or whatever it is, or identifying areas where there shan't be anything. But it's that updated project design phrase that I really struggle with to understand that. The next part, I think is all right. Completion of analysis, preparation of site preparation of site archive. It's just clumsy wording. What you're really saying, I suppose, is that anything that's recovered needs to be properly recorded and archived in that sense for deposition at a store co-op. I don't know. I've got a clue what the heck that is on about, if I'm being honest with you. This is why I'm challenging you to say this is not a justifiable condition. And you get these from your consultees all the time. And I say in 1,001 inquiries, just have a look what they're saying and write it in planning terms, because that's not right. I don't know what it means by the store. I assume it's the archaeological records store.
I assume so, yes, and where they keep any artifacts that are recovered, etc.
Absolutely, but we're assuming, which is not right. So that's another condition that requires a bit of a rethink.
Sir, sorry, may I ask, are you content with the phased discharge as the
Yeah,
principle? Yeah,
if that's what you think's appropriate. But
Yeah. the
to
only,
me, it's just saying you could have all them in one. Well,
Yeah.
you can't have them in one because you've got to wait while there's been sequential investigation. But yeah,
fine, thank you.
15's all right, except the title SEMP, the bit in between says construction method statement. I assume you meant construction environmental management plan, but you've strayed then into construction environmental management statement, which is different. That's just me being pedantic there. The statement shall provide at a minimum the park. It doesn't ask you to provide the details of. It just says the parking of vehicles and site operators. So the statement, I'll make a statement. I'm parking vehicles on this site. I've complied with the condition. Because that's what it says. You've not asked for the details. So there's a little bit just missing. The details as a minimum should provide for. It's the details you want. I don't have a problem with the content. The only thing that I have sometimes a bit of an issue with from experience is F. Sometimes wheel washing doesn't work. Sometimes road sweeping is an admission that it's not worked. And sometimes there might be other measures that a developer could think about. And bear in mind, there'll be a few of these, depending on if you've got different developers in different places, about how they manage the prevention of deposition of materials on the public highway. It could be a shaker area. It could be something else. Sometimes I just say, well, it's easy just to have a scheme to ensure that there's no mud. And only in the event that that scheme fails, shall there be a road sweeper. But in any event, you capture that under highway legislation as opposed to planning, but it's another matter. But it's just saying being prescriptive about wheel wash facilities is sometimes doesn't work because they don't maintain them. All you then do is drag stuff out of the wheel wash back onto the highway. You finish up putting the road sweeper on, and before you know it, you just finish up road sweeping all the time. So ask them for a scheme, because I get them to think about it, really. I put working hours, but you've got a condition on working hours later. So all that condition's doing is trying to think about protecting the environment when they start to do the construction works. And it's specifying, it's a standard condition you see in many places, and it's usually called a construction environmental management plan. But we've strayed into some language a bit here. We just need to think about and tidy up.
With regard to the housing estate that they've just well, they're just about in the finishing stages now in Lakeview, Fieldview, sorry. We've had building material come from that site into our lake, building sands and oil from construction site plant vehicles. So that would be a worry for us on the new home site, should it go ahead, that building materials and operational oils and lubes will end up in the water table.
Just on that point, then,
The last time,
you've got part D of that condition requires storage of plant and materials used in. So you want details of that. Taking on your point, I'm thinking of minerals here. They often put things about oils and where you store oils, etc., in bonded facilities. So you could expand that condition, which is important here, I think, because of the relationship with the watercourse.
Yeah.
About whether or not there are certain materials that need to be put into storage facilities that are bonded to prevent any leakage, either into the ground or to the watercourse. Not all materials will have an effect on that, but some might.
the Environment Agency did come out and inspect it when we had an issue with it. And of course, that will then run into the river, which will then go further on.
So it's just an add-on to that condition about just being clear about the storage, and there's also materials or liquids that could leak into the strata and the watercourse that need to be thought about. You don't need to be too specific, other than just ensuring that the scheme that comes in thinks about that and deals with it. Thank you for that point. 16 is tree protection measures. This is one of these that I didn't have an issue with. It's not like me. I'm slipping here. Oh, just a minute. Oh, let me just read it. No development shall take place using trees and edge of retain and being protected. Right, that's fine. The only thing you might want to think about, which I didn't think about, was whether or not those protection measures are retained, because they can provide them and take them down, unless there's something that I'm just skim reading that I've not read. You've got it. Barriers shall be erected before equipment machinery are brought onto the site for the purpose of development, and shall be maintained until all equipment machinery and surplus materials have been removed from the site. Okay, I'll let that one go. That's all right. 17, I have a bit of an issue with. 17 relates to the drainage outfall. It comes back into the points you've been making today. No development shall commence on a phase or subphase until the following drainage outfall details for that phase or subphase have been submitted and approved in writing by the local planning authority. That's fine. This shall include the details for the location. What I'm struggling with is the next one. Agreements required for outfall locations to be implemented. What agreements? What you think? What's that?
I think so. That can be things such as if your outfall is into a highway drainage ditch or other things similar to that.
So what are you wanting there? Are you wanting details saying I'm going to apply for an agreement, or I've got an agreement, or is the fact that you can't do it without a formal agreement that's subject to another piece of legislation? What are you wanting?
So it would be evidence to prove that where a third party consent or agreement was required, such as highway authority to discharge, that the developer has that in place. So
you're wanting the scheme to define areas where, well there's two things here, chicken and egg here, I think, haven't you? Because you're wanting the agreements in place at the same time this scheme submitted. So you've not approved the scheme. So if you've not approved the scheme, how can they get agreement? Because you might want a different scheme.
True. I think
have a think about it.
Yeah.
I'm struggling with that condition. I understand what you're trying to seek here, and the scheme should include, it should identify where the discharges are, and it should identify the discharges that's going to require consent from another authority, whether it be the highway authority or whatever it might be. Whether or not you as a planning condition require demonstration that consent's been granted is another matter, because you could argue the fact that, yeah, it does need that consent and they can't build it without consent anyway, which is not a planning matter, it's a matter for that other piece of legislation. But as it's worded, you can see why it's a bit clumsy, because you can interpret that you've got to have those agreements in place before you can submit the scheme.
Yeah. No.
Because agreement is agreement. It's really, you're wanting to identify where there is a separate piece of legislation that needs to kick in to allow that discharge. And your assumption, as we're told, the assumption is that regulatory regime will work, and therefore it shouldn't be a planning matter. I'll leave you to have a think about that and read the MPPF. All right. The next bit is a bit confusing. Confirmation that they're confirmed. Confirmation that they're confirmed, not the approved. outfall locations have an adequate capacity for the proposed drainage rates and the volumes and are in a suitable condition. Yeah, you can see why I'm struggling with that one probably. Confirmation that the confirmed outfall locations, is that the ones that you're approved or the ones that they're seeking approval of? Have adequate capacity. Well, if they haven't got adequate capacity, the scheme's not going to work anyway, but that's going to be part of the scheme. That they're in a suitable condition. That probably comes back into the condition I've got later about the CCTV, which I struggle with because it doesn't require to do anything with. But that's probably where that CCTV condition might have to dovetail into this one. Because when I get to the CCTV condition, it doesn't require to do anything other than do a survey. You don't have to do anything with it. It just requires you to do one, which is for what reason?
Can I suggest that the council planners consider removing that word adequate? Because I think have capacity or don't have capacity is the issue, isn't it? If they do have capacity, fine. If they don't, they don't. And that's where you have to enforce the condition. But adequate is I think it's a vague word. I was always taught never to approve vague words like that.
No, have a think about it. No, you're right. I mean, I assume, and I don't know, there'll be some additional capacity built in there as well, I assume, in the scheme. But it's a clumsy condition as worded. But when we get onto the CCTV condition, that's where where my concerns might be resolved, because you need to probably do a CCTV survey of some of these discharges and outfalls, which I think is what the condition's asking you for, to decide if they're in a suitable condition to deal with the drainage. And if not, there needs to be a scheme to ensure that there's measures put in place to ensure they are put into a suitable condition. And that's where that CCTV survey would kick in. But even so, as that's worded, you could say, well, they're not in a suitable condition, but here's my drainage scheme. Because if they're not in a suitable condition, what the next part is, you'll need to have a scheme to ensure that they are put into a suitable condition following some kind of survey. And that's not what the condition's asking for. I'll leave you to have a think about that one. 18, no development shall take place until details of the management of surface water on site during construction, including being submitted to improving right by the local planning authority. That's fine. Total surface water discharge rates during construction, including any groundwater dewatering flows, are not to exceed the rates set out within the approved drainage strategy. Right. Okay.
Sorry, can I just ask a question?
Yeah.
I don't know if I misheard, but is some of this water due to go into the local highways water system? Is that what I heard earlier? Some of the discharge of
There
the
could be
water.
some drainage into the highway system.
So once it hits the highways drainage system, whose responsibility is it after that? Because most of that water off of the dual carriageway from there will go into the river system. So once it comes down from the building site into the highways drainage, who then takes responsibility a little bit for 500 yards down the road where it actually comes into the river system?
I assume that would be a highway drainage, but I don't know if that drainage scheme is going to do that.
Do you know what I'm saying?
Yeah, I understand your
Yeah.
point. I'm not going to go much further. I understand your point there, because what you really, it's about downstream discharge, isn't it? The effective downstream discharge. And it's how far you go with that condition about downstream discharge. Having said all that, the condition does have an implementation clause in it anyway, but that's another story.
Yeah, sorry, I think obviously with the drainage scheme, it's going to manage the discharge from the site itself to existing greenfield runoff rates. So there isn't necessarily an increase in discharge. It's the sort of the formalisation of it through an outfall in the design drainage system.
As I read this condition, this is only about surface water during construction.
Sorry, yes, I thought we were referring more to a more general point about the.
Well, I think we are, but
Yeah,
um,
but in relation to this, yeah, this is condition 18 is just to deal with water during construction, because we've had experience on a number of sites when you've got the site stripped for construction and therefore there's no drainage controls at all. And when you get heavy rain, what you actually get is just a sheet wash straight off the site uncontrolled. So that's what it's seeking to manage.
so a couple of things on that then. So what will happen, there'll be a strategy submitted, which will have to be consulted by the council, the Environment Agency, probably the Highway Authority, and lots of other people will have a look at that strategy before the condition can be discharged. But as I see it, that condition, there isn't an implementation clause.
We know now from talking to Anglian Water that they're very interested in finding out what's going on. I do believe from reading the Pegasus report that they do, or they have been initially consulted, but they don't know, because they were quite surprised at what we had to tell them. So they'll be taking an interest, I'm sure.
Yep. But just think about the implementation clause, because it just requires you to submit the scheme. You set the parameters, but you've not asked it to be implemented. 19 is where I think you could dovetail that condition back into the outfall and the existing systems, because as worded, all it is a survey that you do nothing with, except give me the results. Probably don't need to say anything more than that. Habitat monitoring plan, I didn't have any issues on that. Condition 20. 20 is about for the commencement, you're doing more habitat monitoring for the retained enhanced and created habitats, including on and off-site biodiversity net gain provision. I could argue about whether or not that template might change, but you can leave it, it's all right. The last part of that condition, the very last part of that page, not the penultimate. The HMMP shall also include details of the legal and funding mechanism by which the long-term implementation of the plan will be secured by the developer with the management bodies responsible for its delivery. Is that planning obligation? Or is that planning condition? You're not going to do anything with that. You're just going to give you details of the funding mechanism and who's going to manage it. Are you okay with that? Is that what you're wanting? Or are you wanting to secure, are you wanting to know by other means what that funding mechanism will be? Because we're back to the obligation then.
I'll have to give that some further thought. So
That might be something that you might need to think about, whether or not there's a dovetail with the obligation, because I'm not so sure that bit is relevant to the planning condition.
Yeah, so we had a brief conversation about that when we were looking at the conditions, as to whether any funding points needed to be in an obligation instead. So we will take that away and have another look at it, but we'll also.
I think it should really be in the obligation as opposed to condition. You can see now why you need to challenge these conditions, especially if you've got more inquiries that's coming up. But there's something not right. I don't know. It's not asking you, all you want is details. I'm not so sure what you're going to do with him in terms of enforcement. You know, you give the details on putting 10 quid. Putting 10 quid into the angling club, they're doing it. Well, that's not what you really mean, is it? There's got to be a proper funding mechanism somewhere that can only be, and I think there is something in the 106, if I remember rightly anyway. But I'm not so sure what you're thinking of there and where it kind of sidetracks with the 106. Just turning over the page, I think I'm all right with that. The plan should also set out where the results from monitoring show that conservation aims and objectives of the MP are not being met. I've got a problem with what you're trying to achieve there, but I have a problem with the HMMP plan is the Habitat Management Monitoring Plan. So you don't know if you're not meeting things until you do the surveys. So is it this plan that's showing the conservation aims and objectives? Or is it something else? Because this plan's just about monitoring. Where are those conservation objectives in that plan? Is it the aims and objectives of management? I'm being a clever dick by just saying I don't know what conservation aims are, because conservation aims is not in the rest of this condition. Management aims are. So I don't know where you're expecting those conservation aims to be defined such that you can do the monitoring to see if they're being breached. Because this condition doesn't ask for conservation aims. It somewhere else does, I'm sure it does. But that the condition is worded doesn't. I'll leave you with that one to think about, if you see what I mean. Probably needs to refer back to something else, some other plan or something else in the EIA, where those conservation aims are clearly defined, and that's what you're monitoring against. But the condition doesn't say that from what I read. You okay with that one? Have a think about that one.
Yes, thank you, sir. Yeah.
21, I ain't got a problem with 21. What I have got a problem with 21 is saying badger. And sometimes what that's doing is alerting to badger debaters as badgers on this site. And a better word might be to use the word protected species, because everybody knows what you mean. And badgers are protected species in that sense. But when you put the word out there, it's badgers. You immediately put in the public domain, there's badgers present on the site or likely be badgers present. And that, in my neck of the woods, creates other issues that you don't want.
I do know there are badgers on the sites. I've seen them. I've seen the sets. I walk my dog around this site,
Yep.
as I've said, and I can see evidence of badgers, foxes and deer.
Yeah.
So it's quite prolific with wildlife.
All I'm trying to do is not put the term badger, because you get badger baiting, but put protected species, and then it's a little bit, everybody knows what we mean in terms of those, but you're not saying badgers, because sometimes that creates a little bit of an issue.
I've also seen birds of prey on the site that are quite rare, things like hobbies
Yep.
and merlins, and they are very rare. So, I think that should also be considered with the trees and nesting, stuff like that.
Well, that'll come back into the mitigation works that we've just been talking about and the surveys.
Can I just clarify, obviously the reference to sets and commuting routes, do we need to
Just have a think about it.
just put some
You don't have
slightly
to do,
different wording in there?
because it's only me thinking that sometimes I've had it in other forums where alerting, by using the word badger, immediately it's out there. And you could probably argue, well, the protected species, they'll probably twig what it is anyway. But it's just, there's particular unsavoury activities sometimes occur with a badger. And it's just being sensible about not putting the flag out. Badgers, just kind of recognising that, yeah, from a conservation perspective, we recognise it, but from alerting everybody by putting the flag out, there's badgers here, is a different thing. You don't have to do. It's entirely your choice. It's only me saying, well, sometimes I've had that where that's created an issue. It's kind of put the flag out. Come on, yep, have a look. There's
Yes, that-
badgers.
The council does normally redact any mention of badgers from anything that it puts on its website. But yeah, I take the point that in the
Yeah.
condition, it
Yeah.
probably needs thinking about too.
All right, that's by only being me pedantic about that because I've had past experience where it's come back to bite somebody. Now this is a big one for you guys, is a surface water drainage condition. And this is where you're wanting to see all the details of that surface water drainage strategy in parts A to I, which I didn't have a problem with on any parts of H to Y. I'll come back to you in a second. The only part I did have was when we move on from that. Any above ground storage, bricks, aggregates, wood, or water. I don't know what you mean. Is it water or is it materials?
It's above ground storage of water,
Right,
I believe, sir. So it's, yeah, we're talking about attenuation basins, etc. So you couldn't have designated areas for storage that were also used as a car park, for example.
so it's water storage.
Yes.
In terms of precision, test of condition, it's
Okay.
water storage, above ground water storage. Should the development be delivered in phases, each phase of surface shall be required to manage surface water rates and volumes in accordance with its proportion of the allowable site drainage. Does that override the strategy? That's kind of an aggregate just seems to be trucked in there that says, in any event, you can't do it when you can't exceed the proportion of the allowable site drainage, wherever you find that from. But in any event, you won't approve it if you are exceeding that. That I'm not so sure what you meant by that, and I'm not sure it matters anyway. And then similarly, surface water drainage during construction shall be limited to the rates of the permanent situation. Oh, what's a permanent situation? As it is now? As it will be on completion of development, completion of that phase? I don't know what on earth permanent situation means. Do you know?
I'm not 100%
Don't
sure.
answer it. It's all right. I'm making a point. I'm
Yeah.
making a point that you can see why you need to put the planner's head on things that are thrown at you. Because I ain't got a clue, and if I ain't got a clue, then somebody who's trying to discharge that condition is probably thinking, what we're thinking about that, and I better get in touch with somebody to find out what we want in here. I don't know what the rates of permanent situation are. But that's a condition that's trying to capture a detailed drainage scheme that has to be submitted, capturing all those points in A to I that requires them to be submitted for consultation with appropriate bodies before it can be discharged. So that's kind of your protection measure that we've talked about. And I assume the submission of that will be advertised on the council's website.
Sorry, can you say the last thing again?
The discharging of that condition as an application to discharge, that would be available to view on the council's website.
Absolutely, yes, sir.
So the point making there is, and I don't know how you keep your intelligence up, but whatever's submitted, you'll be able to see. So it's out. It will be out there, but that's your safeguard condition, really. But those last bits of it, we were all right up to there. Then we've gone a bit astray in this last two paragraphs. That I don't know what that means. The next one, no building shall be constructed above slab level until a scheme for the provision of the implementation of foul water drainage, including connection plans, etc., be submitted to. I ain't got a problem with that. in terms of its principle, but what I've got a problem with is that condition requiring to be discharged for the whole site or for the relevant phases? Because as I read that foul drainage scheme has got to be provided for the whole site. Or did you mean for the relevant phases?
We could certainly include some wording, sir, to allow for phases or sub-phases. I think that in discharging that, the council would normally be happy to accept a partial discharge application and deal with that on that basis, but we could add some wording to clarify that.
I
that's
think you need to
acceptable.
clarify what you want, because I could interpret that saying you can't do that. You need to require the drainage scheme for the whole site to be discharged because you've not split it down into phases or anything.
We'd welcome phasing, so.
It's a simple correction, but it's just being clear what you want. The SEMP, condition 24, no development shall take place, including groundworks, vegetation, in each phase or subphase, fine until a SEMP has been submitted, proven right by the local authority. The SEMP biodiversity shall include as a minimum, it's probably details of word again that's missing. And I've put risk assessments of potentially damaging construction activities. Is that for me? Is that my personal risk assessment? If that's damaging construction, I'm going to get noise, any industrial noise. I'm going to have that risk assessment. I'll submit you that. That's not what you want, is it? It's, so I've put my kind of query, it is risk assessment for the potential of potentially damaging construction activities to what? Identification of biodiversity protection zones. All right, I can understand that one. Then practical measures, both physical measures and sensitive working practices, to avoid or reduce impacts during construction to sensitive ecological receptors. May be provided, you don't have to do it, as a set of method statements. That's not precise, is it? And how does a method statement differ from what you require from the rest of the condition? But the word may, you don't have to do it. That's not a precise condition. I'm not going to do that. But what on earth is that? The location and time of sensitive works to avoid harm to biodiversity features, which is what you're really trying to protect, but you only say that actually in part D. E's fine, F's fine, G's fine. Use of protective barriers and exclusion barriers warning signs. Do you not want to know where they're going in that scheme? Because as that condition's worded, you've only got to say, well, yeah, I'm going to put some warning signs up. I'm not going to tell you where they are. I don't have to tell you where I'm putting the fences. And I don't have to tell you what the fences look like. And I don't have to tell you where I'm putting the exclusion barriers or what they look like. I've only got to tell you that I'm doing it. And that's what's missing from that condition. There's no plan showing where you're going to put all these, what they look like, so you can make an assessment as to what they're going to do. All it's doing is saying you're going to use them. And the rest of the implementation clauses, okay. '25, I had a problem with the interpretation of 25. And my problem is, do you mean things like street lights? Or is it every single lighting element of the whole development? In which case we get into some really technical issues, I think. Lighting design strategy for biodiversity, get all that. Submitting right for approval local authority, absolutely fine. Identifying areas that's sensitive to bats, fine. Likely to cause disturbance. And it's going to show how and where external lighting will be installed. Is that external lighting on each dwelling? And if so, are you going to remove PD rights? Or are you just meaning street lighting, major through lighting? Or are you really trying to control everybody's individual dwelling lighting. And I don't know if that is what you're trying to do, in which case you might be in some, different territory.
I don't think the intention is to control people's PD rights and what people do on individual properties post-construction. So I think it's yeah, it's more to do with that street lighting and any other public lighting that's provided from the outset of the development, really.
So do you want to make that condition a bit more precise? Didn't have a problem with the noise mitigation because you've got the noise stuff in the environmental statement. And you're saying that get the details before each phase. Oh, wait a minute. No, it's because it's each reserve matters application, related to residential use for each phase. That's all right. Fire hydrants, I didn't have a problem with that. That's an example of a simple condition that straightforward, precise. I know what you want. Bus stops. The development shall provide 2 pairs of bus stops, which shall be located on the main internal spine road and or on the A422 or on Banbury Road in close proximity to the site's southern boundary. Do you not want to know where they're going then? Because as I can see, as I read that condition, I can put them on the spine road, or I can put them on the A422, or I can put them on Banbury Road, but it doesn't ask you where you're going to put them. You just, all you want is a design.
I think so with that, it's sort of currently unknown as to exactly how the bus services will potentially be diverted and rerouted. So it is left open with options deliberately so that once that's been agreed, it can be.
Does the condition not want you, when they get to that point and you're approving those details, do you not want to know where it's going? Because there'll be other considerations such as highways issues and all sorts of things. The condition as I read it gives you the option. I can understand that there's option at that stage, but when you get to the point of submission, you should know where these bus stops are going. And then the rest of the condition deals with the design. But the condition is worded, all you want to know is the design, and then you can stick them anyway, anywhere you want, with those parameters.
It does say location in both paragraphs. Details of the first pair of bus stops, including location, shelters.
Fine. Yep, that's me. And I do apologise for that one then, because I'll be getting ahead of myself. But you've got the location covered in that one then. All right, we'll stick with 28 and then we're all right with 28. 29. There's a bit of I've got a problem with 29 as to whether this is section 278 stuff. But in any event, I don't know what the first paragraph means. Prior to the occupation of any dwelling to cause tactile paving. What does that mean? To cause tactile paving to be provided in the following law? Prior to the first occupation of any dwelling to cause tactile paving to be provided in the following locations.
I think so. To cause is another way of saying, to implement or to deliver. It could be reworded. Is
this not section 278 stuff? Does that not come in the design of the highway scheme, the detailed design?
It certainly would come under section 278. I think because they're off-site works, there needs to be some way of sort of tying it back to the planning permission to make sure that those works, because they're remote from the site.
So you're saying that that tactile paving is not associated with it's not within the highway?
It's within the highway, but it's not actually sort of within the site. It's not part of the site access works. It's a sort of a third location. So it's not related to creation of the site access. If it wasn't conditioned, there wouldn't be anything obligating the developer to deliver it.
Is it in the red line boundary?
No.
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 Question, sir.
I'll come on to you in a second.
Sorry.
So is it within the appellant's control?
We can include it in a section 278. So I don't know whether you'd be open to an usual informative on the requirement to enter into a 278. And we can include
We
it.
don't put informatives on the planning
Okay.
inspectorate. The reason I'm querying it, I'm querying about the language a little bit, but I'm querying whether or not this is 278 and whether or not, if it's not within red bound of the planning permission and not within land of the control of the applicant, is it enforceable? But if it's highway land, which I don't know if it is or not, where it's intended to go, then the 278 captures it. So why do we need the planning condition?
Yeah, it is highways land, sir. And I think, as Dan said, it's 278, agree, 278, but from Mr. Callis's point of view, it would probably be how the council ensure that it's included in the 278, so to speak.
Right. I'm struggling with that one because you're duplicating the controls that are available from a different set of legislation. And it's totally in the control of the Highway Authority when it's discharging its 278 agreement to ensure that it gets these. So why is it asking you to do them? I know you can't answer that because the Highway Authority's asked you to do it, but it seems to me this is another one of those conditions that's duplicating the controls that's in another regime, and that other regime is better placed than the planning regime for dealing with these matters because it's part of the detailed design of the junction works. So why are you getting involved with that? Because they can't do that unless they discharge a 278, and if they don't do these things, the Highway Authority is not going to deal with it. I know I'm looking at you in a not a good position because I know how councils work. But just have a think about whether or not, again, think about the tests of conditions. The enforcement of that, would that be you or would that be the Highway Authority? Because you'll be enforced against the Highway Authority eventually. Yeah. So if you were to enforce that, the test of conditions, enforceable. It's enforceable, but you're taking action against yourself.
No, we would, so I think we would be taking enforcement action against the developer if they sought to occupy before. So it would be essentially, stopping the development if those works were not.
But it's
Already in
not
place.
within control of the developer, is it? The enforcement notice would not also be served on the Highway Authority as a landowner. I know where you're coming from, and I know the pressure you're under, but it just seems to me that it's duplicating the section 278 stuff that you shouldn't really be doing as a planning condition because it's controlled by a different set of legislation. And unless the design for those junctions provides these, then you're not going to approve the design from a Highway Authority perspective. And unless those are put in then, pursuant to that design, you're not going to discharge the section 278 agreement and adopt it. So you the control's not necessarily with you, unless you're going to go out all the time and check whether that tactile paving is put in and is it the right tactile paving into highway standards, which you're not competent to do in the right place. The Highway Authority are going to do it. Have a think about it, have a chat internally about whether or not that's a 278 condition, but we shouldn't be duplicating things in planning that's enforceable through another regime. In this case, it is enforceable through another regime, and it's that regime that's asking for it in this case.
Okay, thank you, sir. Yeah, we'll take that way.
Don't take this to heart, because I know I've been in your shoes, and I know why sometimes you just want to get these people off your back. So sometimes you'll put in what they say, but when you think about it in the test of conditions in a forum like this, if it wasn't in this forum, nobody'd say anything about it. But when I've got to go through and challenge you about the tests of conditions, that's the reason why you're getting all those queries. So it's not a criticism of yourself. I know why you've done it, and I've been in your shoes, and I know how the pressures you get to do it. But in a forum like this, I've got to have to challenge you about whether it meets the tests, and that's all I'm doing. So I'm not trying to be a clever dick. I'm just trying to say I've got to wear a different hat about those tests, because I've got to put in my report whether those conditions meet those tests. So that's the reason why. Could argue about 30 as well, but I'm not going to do. Yeah, of course you can. Sorry, I thought you made the point about the Highway Authority. I do apologise.
Right, I mean, first of all, I was going to ask where that condition has come from. Has that come from the highways sort of deliberation on this, Highways Department?
Yeah, it's come out of the discussions we've had with West Northants Highways during the course of the application.
The reason I'm picking up on this, because this is a point I made in my submission earlier, sir. Prices Way and Rose Drive are two of the cul-de-sacs that back onto this development.
Yep.
And that's where the concern is that that will only be pedestrian and or cycling access, no vehicle access through these ends of these two cul-de-sacs. So I'm just checking, is there confirmation that there won't be vehicle access?
Yeah, there won't be any vehicle access.
Okay. Yeah, and Mark may know this better than me because he lives near it, but I don't know if there's tactile paving there already or not. I'm not sure. I walk up Humphreys Drive quite a bit, but there's quite a bit of tactile paving at some point.
Up to the entrance to the field, there is a footpath because there's a house that backs right onto literally the hedge row around the field is one of their borders for their back garden. So there is pavements all the way up to the.
No, that's not. Sorry, Mark. That's not. These highway improvements refer to existing junctions off their site. They're not on their site. They are existing junctions off Humphreys Drive. Clearly, if the level of activity increases, then there'll be more people backwards and forwards to and from. But I say it's outside of the site, and I think part of these, some of these may already have some sort of tactile type paving on already. It's on the Humphreys Drive part of the junction, not on the field side.
No.
Yeah.
Mentioned Rose. What was the name of the road? Rose Drive. Yeah. Well, we've got a member that their house actually is the last house on that road.
Yes, I'm aware of that. Sorry, Chair. I'm aware of that, Mark, but these conditions refer to where Rose Drive comes to Humphreys Drive and where Price's Way comes to Humphreys Drive, not on the field side. It's on the existing Humphreys Drive side. Yeah. Sorry.
All right, I think I'm going to ask them to just have a look at that, because you've picked tactile paving out, you could pick all sorts of things out. Show me where the litter bins are. Show me where anything that's on highway land. Show me the specification for the tarmac. Show me the spec for the footpath construction. But you've picked tactile paving, and it's kind of, it's section 278 stuff. It's not planning stuff, really, to be honest. All right, we're nearly there. So there's a bit of work about that. I'm not going to say anything about the zebra crossing stuff. I could do, but I won't. The surface water drainage verification, which is important. Prior to the first occupation of a dwelling, any phase of subsidy verification report shall be installed. I ain't got a problem with that. The only problem I have got is that you've specified a chartered drainage engineer and not a competent person in that sense. You could have a drainage engineer who's chartered who's only got 1 year experience. You could have a civil engineer who's 30-year experience in drainage design and installation. Which would you want to see? But when you start to be specific, you've narrowed it down. I don't even know if there is what is a chartered drainage engineer, member of the Institute of Water Management or something? I don't know. But all you need to ensure that verification report is done by somebody who's competent, and you could ask for that competency to be demonstrated, that they're competent to give you that report of verification. But when you narrow it down like that, it's just being specific to that particular discipline, or sometimes might not be the best person to do it. So just have a think about that one. I don't have a problem with the rest of it, because that's what's saying, right, we've approved the drainage report. This is important to the people around the table, and this is all the verification that that's been done in accordance with what's being approved. So that's kind of the sense check and the reassurance that having gone through all those hoops and hurdles to approve it, this is the one that has to be verified. It's somebody independently has got to verify it to ensure it's all been put in as it should be.
With regard to the surface water, are you aware that in the bottom right-hand corner of the site, there is a natural spring which constantly feeds water into the site? So it's not only the surface water that you have to deal with, it's, there's a freshwater spring at the bottom right-hand corner of the site.
I assume that's picked up in the drainage strategy, the IA.
Yes,
It will be.
will be.
The only thing, and it's only just occurred to me, so don't think I'll look at this in detail. This is a verification report. If the verification report finds that there's something not right, should there be another addendum in the condition that says, in the event that it's not submitted to in accordance with the approved drainage scheme pursuant to condition number whatever it was, that there shall be a remediation scheme submitted to make it compliant? Because that verification report might find that it's not right, but the conditions require you to put it right, if you see what I mean. So it's only another paragraph at the end. In the event that it's not compliant, you need to have a scheme that makes it compliant. Yep, we got that. We okay with that? Interpretation boards, I ain't got a problem with that. I'm not so sure the reasoning for that is good, but I'll accept it. I'm okay with that. EV charging, I ain't got a problem with the EV charging points. Some would argue that's building regs, but I'm okay with it. Rugby pitch provision. The reserve matters application with rugby pitch and associated land shall include. I ain't got a problem with that. But the problem I had is what triggers that rugby pitch submission? When do you need that? Because as I read the condition, you can submit that any time. But are you wanting to have that at a certain time?
I think, sir, the provision of the rugby pitch is dealt with in the section 106 in terms of timing of delivery.
So you'll need to see that scheme then before that timing. Or does
Yeah,
it
we would
matter?
need-
If it's
yeah.
caught by the 106, does it matter? Because the 106 sets the timing. You can't put it in until this has been approved. So by default, you can only put it in once it's been approved.
Yeah, so the reserve matters would need to be obviously approved before the rugby pitch was installed, and the rugby pitch installation is
Good.
dictated by the 106. So
For court.
sort of by default, the two cross over.
Okay. You comfortable with that?
Yes, sir. Yes.
I'm sure you I'm sure you will be. But yes, yeah, got the point on that one. Construction hours, that's typical construction hours. Won't go beyond that. 36, I struggle with 36. Where an offence is likely to occur, wow. In respect to development hereby approved, no works of site clearance. I didn't know an offence is likely to occur. How do you enforce that? And is it you that enforces it? So you're anticipating an offence. So you're sat in your offices waiting. Waiting for that offence coming. I'm waiting for that offence. So you're going to monitor this every single day to ensure there's no offence. And then you're going to think, oh, there's an offence likely to occur. So therefore, I'm going to trigger this condition. There's something not right there, is there?
It's vague, so isn't it? It's what we call vague.
It's not precise, but in any event, if there is an offence under the Habitat and Species regulations, you wouldn't enforce that under planning. It's an offence. It's just that. But I'm struggling with that condition as worded.
I think so. Obviously, it's a condition that the council does actually use quite frequently, and it's mainly there to sort of help guide developers and flag this important issue. However, I do completely accept the points that you make, and I think I don't think the council would necessarily have a problem if it were sort of removed from the list.
Yeah, you controls through the
Yeah.
habitat and species regulations, but in any event, when a fence is likely to occur, how the hell do you know that? Yeah, it's, in any event, if the council is continue to use it, it's a poorly worded condition. So you might need to think about that back office as well, but it's not right. You can't have that anyway. That's not that doesn't meet the test of a condition. Unexpected contamination, absolutely understandable. I don't have a problem with that. That's the end of the conditions that's been agreed between the developer, the appellant and the council. There's quite a few of those conditions require amendment. There's a few that I've challenged you about whether actually they are planning conditions or not. So you can have a think about that back office. And I know I've been a bit pedantic there, but there's a good reason as to why I have been. And it's hopefully highlighted some things that is a learning curve for the council in particular, and also the appellant. Don't accept what comes from your consultees to be justifiable planning conditions that meet the test in the PPG and the NPPF, because invariably, if we've shown today, they don't. So be strong and be bold and tell them, no, it's not an acceptable planning condition, because a clever dick like me will say, no, it's not. So just have a think about that. But you can see where some of those pitfalls lie. That from a planning authority, you've got to be right. And some of them are not right. So they can be made right. Don't take a lot of effort to do it, but I'll give you 2 weeks following Friday to submit that revised list, if that's okay. That's the not big deal breakers. They just require a bit of thought and a bit of back office consideration, I think. Are you okay with that? Is there anything else that you guys have gone? I know some of this is going to be, but I've tried to highlight the ones that's important to you in terms of what representations you've made this morning.
I've just got one question left.
Yep.
When it says surface water drainage verification number 31, at the bottom it says reason to ensure that the drainage scheme is constructed in accordance with the approved details and to prevent the increased risk of flooding both on and off site. How far is off site? Is that just to the main local drainage? Is that to the highway? Where's off site?
You've put me on the spot there in answering that one. It's really saying that anywhere off site, there shouldn't be an increased risk of flooding. But
when it states off site, sort of how far is that beyond the buildings? You know,
yeah, the scheme will hopefully demonstrate and mitigate the fact where water's been discharged, and it will show that there's going to be no increased risk of flooding elsewhere as a consequence of this. And in some areas, it probably will remediate things, probably from what you've already got. But really, you could say, well, off-site means what it is, no off-site as far as you go. So it starts of no increase whatsoever from anywhere. And if it does increase it, then it's not meeting the condition that we've talked about earlier in terms of the design, because what you referred to there is a verification report. But the drainage design should ensure there's no flood risk anywhere off-site. So this is verifying that. So in theory, it's everywhere off-site, because that's what the condition says. So if we throw in water somewhere that's increasing risk of flooding, then that's a scheme that probably wouldn't get approved by the council and its consultees. Yes.
Yeah, I don't think we have anything to add. I think it would be not determined, no specific sort of catchment, so to speak.
But it is, if it transpires that somebody thinks, well, actually, the design of that scheme is going to put water and cause flooding, then it wouldn't get approved. because that's what that's trying to prevent, and that's what it's trying to then check, that that's what's been installed, so it doesn't do that. So in theory, I know what you probably think, it might not happen like that, but in theory, everything's geared up to having a proper design, a proper inspection to ensure that it's put in there, and there are parameters as to what it should do. And one of those parameters, it shouldn't cause flooding elsewhere. So,
Yeah, the only reason I sort of asked it is because the end of where the buildings are going to be is only 0.8 miles away from, you know, the lake and the river. So it's very, very close proximity. So
Yeah.
Rivers are the other side of the airport too.
but again, you know, you'll be able to see those submissions. You'll be able to see what's coming in. You'll be able to see, I assume, on the council website, the consultee responses to individual applications. So you'll be able to see what people are saying. So, and I know that means you've got to look for it. I appreciate that, but from my perspective, is there adequate measures in here to ensure that the water environment is protected? Well, I think there is, because that condition requires all the upfront design properly thought through, requires consultation with lots of people before the council can say, yeah, it's approved. And then it's requiring some independent verification to make sure it's in as it should be. And then the add-on part, well, if it isn't, we need some further works to ensure that it is. So in theory, all of that is in the public domain that you can see, and all of that shouldn't cause increased risk of flooding off-site. That's what it's all designed to do. All right. I don't have any other matters on conditions. Anything else that you've thought about conditions that need to be an addition or an addendum to anything that we've said today before we take a break?
No, I
Okay.
think we will discuss with Mr. Callis, but we were talking about the rugby pitch condition
Yeah.
and whether we discuss moving the whole thing into the obligation rather than having the split requirements, but we can have a chat with Mr. Callis about that.
I suppose the only issue on that is you need to have a think about it, because you're looking then at all the, how it's laid out, how it's the soil treatment and everything else, which is, and whether or not the obligation can do that or whether you can need to do that. But yeah, except what you're saying. My only query was, I couldn't see the time frame when that had to be submitted really. But anyway, but it's captured it's by default, it's captured, I think. All right. I'm not going to go through the section 106 like that. So you'll get your tea, don't worry about it. It's just left quarter past, it's 15:17. Are we okay if we just take a break for a quarter of an hour? And so you've got time to stretch your legs, comfort break or refreshments if you wish. If we come back at, I'll be precise, we'll have 15 minutes, so we'll come back at, it's 15:18 now. Come back at 15:33. Yeah, 15:33 to the minute. Let's round it up. We'll come back at 15:35. 15:35. So we'll have just nearly 20 minutes break. So we'll come back at 15:35. We'll just go through sequentially that 106 agreement. So we're adjourned at that point till 15:35. 15:35, yeah. I was going to go 33, but then I thought everybody's going to, yeah, we'll round it up. 15:35. Are you okay?
Yeah.
All right. It's 15:36, 15:37. The inquiry is now resumed. You're flying solo now. Your mates have left you. So you're gonna have to fight your own battles now. But I'm sure you're capable of doing that. Yeah, all right. But welcome you. All right. This next part of the last part of this afternoon, we'll go through the 106. Just a couple of things before I do that, just to be sure of how we're going to structure it and what we've got. I've just been given an updated copy of the sole compliance statement. Can you just tell us, Mr. Callis, what's changed in this version from the previous one?
Yeah, thank you, sir. So the only change is the last row on the table. So at the very bottom end of the report, well, all I've added in is the off-site pedestrian and access works, which is an obligation that has been included in the agreement subsequent to the submission of the original SIL compliance statement at the end of September. And that relates to the pedestrian and cycle access at Harris Close, which is required to go across third-party land, which is owned by Brackley Town Council, it's public open space. And Brackley Town Council are one of the landowners of the site and one of the signatories of the 106. So there are obligations within there that essentially require the developer to pay a contribution to the town council to carry out the work, and then for the town council to carry out that work within a set time frame. And there's various other caveats and provisions within there, but essentially that's what it's seeking to do, because it is at the moment private third-party land, essentially, to access the highway at Harris Close.
All right. You'll need to put your microphone on.
Sorry, Mark.
Can you pull it close? Because
Of course,
you have to pull them.
of course. So
You have to pull them close, yeah.
yeah, no problems. So Marco Mauer, I've been dealing with the Section 106 on behalf of the developer. I'm the developer's solicitor. And I was just going to, just for the avoidance of any doubt, we have included that off-site land as being bound by the terms of the 106 to secure those particular obligations and the positive covenant.
Okay, what I'm going to do then, I'm just going to ask you to take us through this. I'll probably ask you to take us through it. How do I refer to Mr. Mario?
Yeah, Mr. Mauer is absolutely fine.
How do you spell your second name, by the way?
It's Mauro.
That's why I got it wrong. Mauro. Okay, I'm going to flip between the council as well, so just to have a little bit different. I know you've been talking about some potential amendments, so when we go through today, you can tell us where those potential amendments might be and what the implications of those are.
Yep.
But I'm going to ask you to just take us through, not every single line here, just the principles of certain sections and obligations, what they're seeking to achieve, and then if need be, we'll have a discussion. Apart from some nitty-picky things like naming a person. Oh, sorry, that's you. Yep. Right, is that better? Okay, what I'm not going to do, I'm not going to go through in nitty-picky detail. My only comments, so there's a couple of things where just want something interpretation, if I got that right. And then it's only my thoughts about whether or not, and that's a matter for yourselves really, whether or not naming a particular post is the best way of doing things, but that's probably a council thing because things can change. And it gets a little, because it generally, in general terms, it's just the council's approving these things. I don't know whether you need to have a person in there, but I'm not going to get hung up on that if that's comfortable to the council, if it works, but there are some pitfalls in that, I think, as well. But
Sir, there are certain posts like 151 officers and monitoring officers are going to be always imposed. There's going to be someone imposed because we are a local
they're in
authority.
statute though, aren't they?
Yes, they're statutory officers.
The director of place and economy is not.
It isn't, but there needs to be an assistant director. And there should always be an assistant director, but we are willing to have replacement, have wording that includes successors to that post or replacement titles of
All
that
right.
post, if that would make you feel more comfortable with the
I'm
106
okay with it.
agreement.
It's just me saying, well, just approved by the council, it can be, as long as the council approves, it doesn't matter. And unless you've got and I'm thinking about, you can go into more detail about delegated powers and all sorts of things. Does the delegated power of that new posting have the same delegated powers as previous ones? And it's your problem at the end of the day. I want to do it, but it's your problem.
I think, sir, that because there was just one or two things that came out of the conditions talk that we said that we can easily pick up now in the, it makes sense to just pick those up in the section 106, which we'll go on to in a minute. It probably just makes sense to sweep that up as part of it.
Yeah.
So, and Sean's come up with some wording, and I've got no objection with that wording, so.
I used to have that post, and I've never recall in my time a section 106 agreement that specified me in one.
Yeah.
Leave it at that. You're all right. Whatever you're comfortable with at the end of the day, but I can see why. Yeah, it might be a little bit constraining.
We'll look at it, sir, and I'll have a chat with Mark.
If you don't worry about it, because it's your problem, that one. To be honest, but it's just me being pedantic. I probably want to do it that way. All right, so if you can, sorry.
No, sorry. Go on.
I was just going to say, just take us through the principal parties, and then I'm going to just ask you to take us through some of the key definitions, not all of them, the things that you think that particularly people around the room might want to know, but don't go through it verbatim. But just take us through the parties to this agreement, a little bit about their roles, then take us through some, well, explain the definitions and the that's in there, so we understand the reason for that, and if there's anything particular that you think you need to draw our attention to, there might not be.
Sure. No, that's
Okay.
fine. So, yeah, as you know, the section 106 needs to bind the application site, and there are four principal landowners, which is the Stewarts, the first landowner, Ashfield Land Developments Limited, second landowner, Volps Holdings, and then Brackley Town Council. So they are the four landowners. Davidson's developments have contractual arrangements in place in terms of purchasing the site, and Volps Limited also have an option as well. So there's equitable interest there. So we've made sure that obviously they are all included for the purposes of obviously securing the obligations. It might be helpful to just talk through the principal obligations in terms of the schedules, and then go back to the definitions, because I think that's probably going to be a lot more user friendly.
Whichever way you want to do it, yeah.
Yeah, I was going to say, so the second.
Chip in if you want to do. Chip in if you want to do. No, it's not. It's not.
Public
It's not
document.
confidential. No. If you're participating in another town round the round table discussion, then you need to be in a position that you can discuss if you wish to do so. So I don't want to deny you the right to not know what we're talking about. It's important that you know what we're talking about. You're the last person representing the community today. Yep. Okay. All right.
Yeah, I mean, it's worth obviously
Carry on,
it's worth mentioning that subject to just a couple of points that we've discussed now. I mean, the document has been agreed with the council and the parties. So yeah, second schedule that deals with the affordable housing. It's 40% affordable housing, and requirement for delivery of that affordable housing is set out in paragraphs 1 and 2 of the second schedule, to make sure that obviously only certain numbers or percentages of the market units can be occupied within a relevant phase until the affordable housing has come forward. In terms,
just before you leave, that's the only point in detail that I made a comment about.
Pardon?
That's the only point in detail that I made a comment about. Just that one.
Right.
second schedule, and it's only about, it's more of a control perspective about knowing the trigger that 75% is not being exceeded. What captures that? How, in terms of enforcing the agreement, what captures that trigger? Who's doing the counting to ensure that right, this is the 74th percent?
Obviously, if we, if we exceed the, I suppose there's a couple of things. First, obviously, if we exceed it, we're in breach, so we can't do that. But in reality, we will struggle to be able to satisfy any purchasers because, of course, those purchasers are going to say, well, you haven't, we're not going to take this in breach of those obligations. So, yeah,
All right, as long as you're comfortable with it, I'm not going to criticise it. It's just me thinking from the previous discussion we had, who's going to know that trigger's being reached? Eventually, when you know exactly the number of dwellings on the site, you can calculate that numeric value. You can't know.
you're
because
going to
you don't
know
how
from
many
reserve matters of it, won't you? So you'll know how many have obviously been
Yeah.
approved in each of the reserve matters. So
It's all right. It's just whether or not the council requires anything to trigger notification that threshold's been reached or not. That was the only detailed comment that I got, and that's where in my planning condition head's thinking, how do you know that this is 75%? How do you know to say actually, oh, there's a breach here? And I know what you're saying, but it's just kind of from your perspective. If you think it's fine, you're comfortable with it, it's fine by me as well, I think. But it's just me saying, well, there's a how do you know issue on that one. The rest of them, I don't think there is, but that one there is. It's the only one I've picked up in the comment about, if I'm being honest with you.
fair enough.
I'm being instructed that I can talk to Markham about including, because there's a notification section on page 36. So we can add it into the notification section that your client will tell the council when 74 units or 75 units have been occupied in accordance.
Percentage, but yeah.
Just to
Yes.
trigger it, so it triggered it, because it's obviously triggering the affordable housing, which is really
Yes.
important, as well as market housing too. So,
Thank
all
you.
right,
That's fine.
I do apologise, but that was the only issue I had on that particular part. But please carry on and just explain a little bit more about what that's doing.
That's fine. That's fine. No, we can get that. We can put that within it. So, so yes. So sorry. So that's the so paragraphs 1 and 2 are the delivery to both construction of those affordable housing units and also to be able to sort of transfer them to a housing association. And also paragraph 9 of that schedule requires us to agree the affordable housing scheme with the council as well. So the council has that element of control. As you can probably appreciate, there is a difficulty with in this country with developers being able to transfer units sometimes or be able to secure agreements with housing associations. So whilst obviously we have to try and do that, there are cascade provisions and fallbacks so that if we can't, then we can look at alternative forms of affordable housing, which in this case is a discounted unit or a financial contribution if in a sort of a worst case scenario. So that and then in terms of the rest of the affordable housing provisions, I mean, most of those provisions are going to come down to how the housing association will have to manage those units. And this is fairly standard West Northamptonshire Council sort of wording in that respect, and there'll be requirements for nomination agreements for the rented units that will obviously control that. So I think that in a sort of high level really sort of covers the affordable housing. Then we go on to the third schedule, which is there's a series of financial contributions. We've got education, we've got libraries, we've got indoor sports facilities, we've got refuse and recycling contribution, healthcare contribution, There's a monitoring fee in there, off-site access and pedestrian works contribution, which we'll come back to in a second. We have touched on that. And then there's a public transport contribution, and there's various sort of triggers as to when they need to be paid. And then if you cross-reference that back to the definitions, they are all, in each of the definitions, it will set out how much those contributions are for. Well, yeah, sorry, how much those contributions are for and how those contributions are to be applied.
Yep. Just on that one as well, that's one of those where you also might need that notification as well. Because on the education contribution, occupation of the 25% of the dwellings, how do you know? I don't want to interrupt you too much, but just where we get those triggers, you
Okay.
might need to just think about how do you know to enforce the terms of the agreement. But you can do that by expanding that notification. Dead easy.
Sure.
I do apologise for interrupting you, but just while it were in my mind. I didn't
No,
want to
no,
stray off.
that's fine. That's fine.
Not bothered about the
Easy.
25% of the contributions because you can work that out exactly. You know what that should be because it's in the definitions, but it's just that trigger.
Yeah,
Please carry on.
sure. And it's worth as well just pointing out that there is what we refer to as a blue pencil clause in the section 106. So in other words, if any of these obligations, not just the contributions, but if any of the obligations in the schedule, the inspector is of the view that they are not regulation 122 compliant, i.e. they are not necessary to make the development acceptable in planning terms, they're not directly related to the development, they're not reasonable in scale and kind, then of course, and no weight is given to those, then that obligation then would fall away, or the inspector could amend that in a way that obviously would give effect. So, and that's, as you know, fairly standard drafting for section 106 in relation to appeals. We've also then got public open space, rugby club, and allotment land. It's worth mentioning the reason why we've had to divide these up is because the public open is because of the way they're going to be potentially managed, because the public open space at the moment requires, once that's been delivered, we have to serve notice on the town council as to whether they require it or not. And if they do require it, they have a period of time in which to accept it. And if it is accepted, then we have to transfer it to the town council, and then there is the payment of a management
management fee
contribution. Yeah. If they don't accept it, they don't accept the offer, then it will be managed by the owner and through, well, essentially through a management company. So it'll be done through a management company. Whereas the rugby club land and the allotment land, that's been offered to, well, the rugby club land is being offered to Brackley, just get the official title. It's Brackley Rugby Club. So yes, so that will be yes, that will ultimately be subject then, once the work's completed, will be transferred to the rugby club. And then the allotment land, that's going to the Brackley and District Allotment and Garden Holders Association Limited. They're the ones that have obviously expressed an interest in having that. In terms of the triggers for all of this, the public open space, that has to be so this in the fourth schedule, so that has to be laid out. So it's both the public space and the play areas. They've got to be laid out in accordance with the approval of reserved matters. There's a trigger for delivery of that at 1.2 that requires that to be completed at various stages of the development. And then, as I say, that then will need to be signed off. Basically, we'd have to get that signed off, make sure it's completed, and then there's triggers at 1.3 then that requires then the council to, we've got to notify the council, and then the council have to inspect it to make sure that obviously it has been completed as it should have been completed. And then there's requirements in here then to notify then the town council once all that's been completed and signed off by the council, to offer to transfer that land to Brackley Town Council. And that's all contained within 1.7. They've got a time period in which to accept that. If they don't accept it, then as I say, the alternative would be it will then have to be maintained through a management company. And then the rugby club land, in terms of the triggers for that has to be and this is actually a part that we're looking to make a tweak to the section 106 on, because of the discussions that now recently come out on the conditions. So 2.1 of the fourth schedule requires the submission of reserve matters approval for the rugby club land prior to occupation of any dwellings. What we were intending to do there is we were intending to slot in the condition that we've got about the scheme. So in between 2.1 and 2.2, it's clear what the application for reserve matters has to include. So it will dovetail then what's in and we then take the condition out on that basis. And then we've got timescales here that we can't occupy more than 125 dwellings until we've offered to transfer that land to the rugby club land. That has to be obviously a binding, a written offer to the rugby club land. And then if they don't accept it, then the obligation would essentially fall away. But if they do accept it, which they've, as I understand, they have expressed an interest, haven't they, Mel? So yeah, so there's no reason why they're not going to accept it. Then we then have to deliver that work in accordance with the approval of reserve matters, which will obviously be referenced in the specific wording from that condition. And that's at 2.4, and we can't then occupy more than 50% of the dwellings until that work has been completed. And then when you follow that through, it's then going to then have to be transferred to the rugby club in accordance with the terms of the written offer.
Just in terms of the planning benefits that have been asked to weigh, you mentioned there, and I don't, well, correct me if you're wrong here. You said that if the rugby club doesn't accept it, the obligation falls away. So I could argue all that benefit's gone then, hasn't it? But I don't think that's what you mean. There'd be some other management regime for that land, wouldn't there?
Well, in terms of the work at the moment,
In other words, what weight do I give to something that might fall away?
Well, I mean, at the moment, the work is the way it works is that we have to we offer it first.
Yep.
If they're not interested in it, then there's no requirement on us as it stands for us to carry out the work, because from our point of view, we didn't want to have to commit to something if there was no sort of no requirement for that. Though those were sort of my instructions. But
okay, the only thing I will say then is that if it falls away, then I'm not going to attach much weight to something that's not secure. So you might want to have a think about that, because obviously there's a playing pitch provided to a standard as part of the reserve matters application. It should be available for the rugby club, but if the rugby club say we're not interested now, do you just leave it? I'm sure you won't.
So I may revert to Mr. White, however, on the weight to be given. I think
I'm not asking you to comment on that.
Yes,
at all.
apologies,
But it's just that like the other land, the open space land that goes to the town council, if they don't want it, it goes to a management company or wherever. So therefore, there's a regime in there to manage that. The kind of, my ears pricked up when he says it falls away because it's been put down as one of the benefits of the scheme in providing additional playing capacity. And if it falls away, well,
We can look at that.
just have a
Yeah.
think about it.
Okay.
Don't give me an answer now. Just have a think about it and whether or not that's something you need to think about in the agreement, because if not, then it's not a benefit that you can deliver. Because if they say no, you've lost completely that benefit that's not in your control. So whether or not do you have a contingency? Yep.
First of all, knowing how popular the rugby club is now with the youngsters and the full sort of men's and ladies teams, I'll be surprised if they're not interested in this
Absolutely.
pitch. However, clearly it is a benefit of the scheme. So as a local, I'd want it at least a playing field for someone,
I think
or a
that's the
pitch for
point.
someone.
Yeah.
And there's obviously pitches already nearby managed by the recreation centre, they're out to local clubs. There are some local clubs who may be interested in taking on a bigger responsibility over and above
Yep.
hiring out a pitch from the recreation centre, but that would be, yeah,
There needs to be a
something people were keen to keep an eye on, I think.
You need to think about, if you want me to consider this as a planning benefit, you need to think about a contingency, because just to let it fall away doesn't seem to me to be the best strategy in terms of what you put forward as some of the benefits of the plan application.
Yeah.
And there are other opportunities that you could explore about that kind of drop down to offer it to other sporting clubs or associations. And if all that fails, then you spent all that money on putting a playing pitch there that somebody really ought to manage.
Understood.
But I'll
Yeah.
leave that for you to have a think about.
Thank you.
It's only me being pedantic there and saying, well, my ears pricked up when he says if they turn it down, then that's it. And I'm thinking, I'm sure that's not what you mean, really. Because it's a public benefit that you've put in there. And as you say, there's lots of other people would make use of that.
Just saying, our biggest club in the area, of course, is Brackley Town Football Club, but they only have a men's team and a ladies team. They may have youngsters for training and other sessions, but I'm not sure they run youngsters teams. But as an organisation, they are very on the ball. Yeah, they're professional in their sort of outlook already.
There are other community options to explore, aren't there? It sounds of it, plenty of them. It's up to you.
Yeah.
But it does affect what I do eventually. But it seems to me that just to let that fall away is not what you're really intending to do. I'm sure it's not.
In the immortal words, we hear what you say and we will consider it in
Yeah.
depth.
Thank you.
Okay.
Please carry on.
Yeah, I was going to say, so we've got mirror obligations in relation to the allotment land as well. So the allotment land and the arrangements for that mirror what the rugby club.
Does that get caught by the same
obligations do.
issue?
Yeah.
If the allotment people don't want it,
If the allotment people don't want it, then yeah, that would essentially fall away. But as I understand, both the allotment land and the rugby club land presumably would just form part of the open space.
I'm
land
sure there's,
again,
I'm
but of
sure there's a
course,
community
yeah,
demand for allotments. The fact that this allotment management company might not want it doesn't mean to say that community demand's gone away. So again, it's the same category of benefit that.
Yeah, of course.
It can, you don't want to be losing it really.
Yeah.
So
Okay.
do you,
Again, Chair, my uncle's an allotment holder somewhere else within their remit, and they do have a waiting list, but
that's what I mean. Where I live, there's an incredible demand for allotments and there's under supply. So it's kind of, as a community benefit, if that's what's been put forward, is it's kind of, it can't fall away. It can, but
Yeah.
I need to think about that. But so you might just need to think about some contingency in there as to what happens if, and it's just that kind of drop down to eventually the backstop that you've got someone that needs managing. Somebody's got to manage it. And what's the backstop then? Is it that management company or whoever? But there's got to be some, in my view, there's got to be some backstop that you can do.
Yeah.
Okay.
Okay, fine. And then we come on to the fifth schedule, which is a travel plan obligations. I mean, I probably don't need to say too much about those. I mean, they're sort of straightforward enough. I mean, there will be a requirement to pay a travel plan monitoring fee. And as I say, I mean, they're standard travel plan provisions really. So
I ain't got a problem with those.
yeah. We've also then got the sixth schedule. We've got biodiversity. we've got to agree we've got to submit and agree the BNG plan and the habitat management monitoring plan as well with the council. And then we've got to comply basically with the with both plans in terms of the habitat works. It's all being carried out on site. There's no off site, so it's all being carried out on site. And there are monitoring fees that have to be paid as well, and that's set out in paragraph 6.
Just before you leave, that notification of the commencement of development, is that covered?
Notification. So what part?
So when it says the sixth schedule, section 6, to pay the council biodiversity monitoring scheme in accordance with the following installments.
Yeah.
1,000 on commencement of development, and there's lots of things on commencement development. There's a definition of commencement development.
Yeah.
It's just it, and you can direct me if there is or there isn't. Is there
No.
something in there that requires you to notify the council of the date of that commencement of development? And if so, where is it?
Let me just have a
To make
quick
sure the
look.
council knows that when those triggers kick in.
Yeah. It's clause 11.1 at the front end. So we've got to notify, council have got to be notified of the commencement of development, also occupation.
14 days before, that's fine, you've caught it, it's okay.
Yeah.
Yep.
So, yeah, clause 11. And then we've got the council's covenants, which they're set out in the 7th schedule, which in the most part is if they don't spend the money within a certain time period, then it comes back. Or the unspent part, I should say, what's not spent comes back. I mean, in reality, by the time we get to that point, everyone's forgotten about it, moved on, and
Yeah.
on to the
I'm
next
smirking because
development.
I've been
But,
in that position, yep.
you know, and then the 8th schedule is the off-site pedestrian and access works, and these are the works that are the Harris Close
Yeah,
works, the connection works, and this is on the town council's land, which is obviously why then we've had to bind that land. So that work, so you can see, I mean, the time periods for that are set out in paragraph 1, and then if we link back, if we refer back to the contributions schedule, there's the requirement at hold on, it's and the 3rd schedule, paragraph 7, that we can't occupy more than 100 dwellings until that off-site access and pedestrian works contribution has been paid, has been paid to the owner of the of that pedestrian access land. So it'd have to be paid to the town council if you know got ownership of that, but the obligation there is obviously we're given that obligation as a 106 obligation, so it can be enforced by the local planning authority under section 106. But then also when we jump then back to the 8th schedule, there's then the positive obligation then to carry out that work within 6 months of receiving the off-site, or well, within 6 months of receiving that contribution. And I think, I mean, that's the section 106 in a nutshell. The plan for the off-site works are set out. They're actually in the Annex 1. You can see there's a plan, and then there's a sort of like a specification schedule and costing. So it gives some rationale as to why we've sort of come up with the contribution you know, that how that contribution has been arrived at, which is 50,000 plus indexation. So I mean that's the section 106
okay.
high level.
I'm comfortable with that. Is there anything that you've got an issue with at all? There are some trigger issues in there. There are some dropping down issues about it just doesn't fall away. It's been created as an allotment. It's been created as rugby pitch that needs to be retained for that purpose in use by some other mechanism then, if not by those two bodies that's been identified.
Provision is for the pitch and the allotments and whoever takes them on, whoever takes them on.
Yeah.
Yeah. Not necessarily the rugby club or not necessarily the allotment society, but hopefully they will.
Yep. That's only my concern, because if not, then it comes into some other planning matters, but that's a matter for you to have a discussion about.
Yeah. Okay.
I don't have anything else to say on that. It's pretty straightforward in the main. It's not, there's nothing in there that I wouldn't jumping out at me saying, oof, that's not right, or that's unusual. Everything seems to be pretty straightforward. Is there, before I say, well, that's it on that particular matter, is there anything else you want to say, or are you comfortable with it? So what we will do following today's discussion, there are some things for you to have a think about. Do I need to see another draft? I don't need to see another draft. The only, well, if you decide that you are thinking about a mechanism to ensure those benefits can be delivered in the 106 amendment, then through your planning witness, through yourself and through Mr. White, you need to be alerting me to the fact that those benefits are secured. If you decide that they're not, then I need to know about that through Mr. White and the planning witness, that those benefits are not secured, and therefore I would have to give a different weight to some of the benefits that's put before me to consider. So it's up to you as to how you do that. I want to leave on Thursday, knowing which way you're going, probably. I don't need the detail. I just need to know which way you're going, I think, on this, so that I can prick my ears up for closing submissions that's picked that up as well. And then, but I think if you're going with the way I think you probably are going, of having that drop down, I don't need to see another draft. What I will give you is, well, no, I will need to see another draft actually to make sure you've done it. But I'll give you 2 weeks, a couple of weeks to do that.
Well, there are 3 steps, I may say. Obviously, Mr. Callis and Ms. Butterfield will have to address the question of weight in the light of your comments, so it does affect planning evidence. So I think we'll try and give you an update before tomorrow. So we can take it on board before the planning evidence commences. But you're right, in terms of a formal amendment, you need to see that. And also, as you know, and you've inferred it twice, we are going to ask, there are quite a number of signatories to the 106, and we are going to ask for 2 weeks to enable the signing of it.
I'm not hard and fast to that, because where there's a number of signatories, I've just dealt with Mr. Tucker where it took about 8 weeks.
Exactly.
so
Well, hopefully that's worst case, but hopefully we're not going to ask. No, I'm told by my respective clients 2 weeks should be adequate, and we've made provision for that. But tomorrow I will update you on the timescale and the amendments, but I think we need clarity on this before the commencement of the planning.
I would agree with it. Yep. Okay, I'll make a note in my notes just to say that I will ask for that tomorrow. I will ask tomorrow morning before we start the section 106 discussions, not section 6, the HLS discussions where we're at in housekeeping. If not, I'll ask in the afternoon. But either way, I will ask that. I've got nothing further to say on those matters. You think you know where the kind of issues are that I need to think about that are important, obviously, to the community. So we'll leave that for you to have a think about that. There's nothing else. Let me just check that I've not received anything in the last few minutes from Tim that might be relevant to anything today. And I haven't. I'll decline that.
So could I raise, have you got a copy of the A3 Scott schedule now, the bigger one? Perfect, you do. Can I just raise that? Though I'm not going to get into murky waters about the agenda for obvious reasons. But could we get a steer from you, because Mr. Tiley tells me in your Scott schedule, the length and depth of it shows is testament to this. There are 57 sites. Can I just get a feel for, you said this morning, your expectation is to keep to the timetable. And I just wanted to get confirmation. At the moment, we have 3 hours for the HLS.
Yep.
And your expectation is, knowing as you do and having read the material, I just want to get that clear, that with the likelihood is we're going to start Mr. Callis in the afternoon.
Yep.
Great.
At the end of the
Perfect.
day, I've got both your positions on this.
100%. And no, I only
Yep.
said, and so you never have the benefit of this, but Ms. Sear and Mr. Fraser Urquhart and I, some inspectors take half an hour on an HLS roundtable, others can take 2 to 3 days. So it's quite a subjective.
Yep.
So I'm sorry to say this, but it's the same with conditions on 106. So I just, for my purposes, you've answered the question and you've got clear intent to keep to the timetable.
I
And
have.
that's all I needed
What,
to know.
what I want to know, what I want to do, I'm not going to throw the minute at every single one. I want to know the big headliner ones. So I want to know the ones that's really going to have an influence here. So I'll ask both parties to say, all right, well, what are the ones that are really an issue here, that in terms of numbers, and gone off stray from Mr. Tidy's perspective, So here we have it. And I'll be asking is the ones now that you want to draw my attention specifically to that has a serious impact on the deliverability. So,
Okay, and can I also ask?
so I'm not going to say everyone,
No,
and
no,
I'm not going to say none, but I'm going to say, all right, draw my attention to the ones that you think are really the ones that are going to tip the balance here.
that perfectly answers the question, but it leads to a second question, which again influences the advocate's approach. And there are those advocates that have a 28-page appendices highlighting all the evidence heard in the roundtable in closings I'm talking about. There are those that take the approach on the other end of the scale to ignore it because you've got a detailed note. Would you just think about, because obviously it will influence their approach to the closings, what you would find most helpful in the closings in relation to the HLS evidence, whether you clearly take a very detailed note, but would you like an appendices that summarises the position of the appellants and the council in closing, or are you happy for the very brief reference to the HLS evidence? Will you just mull? You don't need to tell us
No,
till
yeah,
tomorrow.
I think
but-
it probably depends what pans out tomorrow.
Well, exactly.
Yeah.
But will you just give some thought to it?
Possible,
Because
yeah.
the last thing I want to do is spend a long time providing you with a very long appendices if frankly it's of no use to you in the closing.
I mean, at the end of the day, I've got both comments. And unless you're going to really come to some agreement, which I suspect you're not,
yeah.
we're just talking on those comments. So
I think that boat might have sailed. But no, okay, can I just ask one other thing? Because I have found this thing, could I just ask through you, and one of the things that does sometimes happen is that there is, the council obviously, because of its position of relative privilege, is in contact with various parties invariably, and it's very rare for a roundtable without a comment being made about, oh, we spoke to the members, or we spoke to the house builder the other day and they confirmed. And I'm not in any way criticising or anything, but can I just say, if Mr. Wood or Mr. Munn have any up-to-date evidence which isn't before the inquiry, would they just email it to us tonight?
I think
I'm not accusing them of having such,
No.
but I'm just, in order to avoid that moment.
Well, I have to say that the nature of a roundtable discussion is often that type of information emerges. And I think there will be some of that tomorrow because.
Well, then I'm just, well, you might be right in a way, but it's obviously problematical. And frankly, it puts Mr. Tyler at a disadvantage if he doesn't have notice of it because he can't react on the who.
Yeah.
So I don't think it's an unreasonable request to ask the question of Mr. Wood and Mr. Munn, if they have evidence that they think is material for you to hear, that we have notice of it, because otherwise it's a problem. I mean, simply put, because we have no notice that, so I don't think it's unreasonable to ask that.
Well, it would have been helpful if this request had been made a week ago, frankly.
Well, it's
that's
inevitable. I'm sorry.
Well, so say it is also inevitable to say that information will be put forward on the day by the council's officers because they have sought will be seeking to provide you with the most up-to-date position.
all right. I think I probably need to make some comment on that then. I think it would be helpful for all parties and me in particular, if we can you won't have the details of this because it might be nothing more than a telephone conversation. But those sites where there's a revision to the Scott schedule because of more up-to-date information would be helpful, I think, because that's helpful to us all. The issue is for me sometimes is, well, if we spoke to the developers, and you could argue, well, they would say that, wouldn't they? And that's a matter for me to think about the weight that I attach to that. And I suspect that you haven't got hard and fast letters and all sorts of things that confirms the current position. I suspect that best you've got phone call information. And I'm looking at you to either confirm that or not confirm that.
Probably my colleague, Mr. Wood, is better to answer that, sir.
You missed the earlier point, I think, Mr. Wood, about concerns from the appellants that you might have information that supersedes this that we'll only find about tomorrow. And the benefit of the appellant being notified where there are updates in advance, so we can take those on board tomorrow as opposed to being dropped in tomorrow in the round table discussion.
Yes, so we certainly have been seeking update information for the session tomorrow, and we thought that was the whole purpose of the session tomorrow, was to update yourself, sir, so that you had the very latest information on all of those sites. It's a tall order for us to do that between now and the session at 9:30 tomorrow morning. And we thought that was the purpose of the session tomorrow, was to say to give you any updates since the Scott schedule was produced.
Are there many?
There are several. Yes, there are. But to say that we thought that's what we were doing tomorrow, to go through with the respective positions on all of the sites and any updates. There are lots of sites that have been challenged, as you'll see from the Scott schedule. So inevitably, the planning world doesn't stand still. It's a moving feast. So inevitably, between when the Scott schedule was produced and the hearing tomorrow, that there will be movement on those sites. There have been planning committee meetings, there have been negotiations on sites, etc. So, yeah, that was the purpose we understood of tomorrow's session. So I don't think it's realistic or reasonable to expect us to put that all in a note. If that's what the appellants wanted, they ought to have asked for that in advance of this session this afternoon.
No, I'm sorry, that's completely not right. I don't want to get into a spat, but it's utterly reasonable. The whole purpose of exchange of evidence is parties knows what's going to be said. And it's just not reasonable to portray us, frankly, as acting inappropriately by asking for this. To have a witness for the council say there is updated information on several sites and provide it for the first, I mean, by definition, it puts Mr. Tiley at a disadvantage because he's got no idea what's going to be said. I am not objecting to the provision of updated evidence, but I do think it is reasonable that we know what is going to be said by the council. In the same way, if I flip this round and said, oh, Mr. Tiley's got lots of updated information, then they would understandably also have a concern.
What level of detail would you require?
Well, so in the absence of, I've got no idea of what Mr. Wood calls there's revisions, updated information. I don't know what it is because we obviously, the fundamental issue is the council have not paraded that and given no notice that they've got updated information. So I just simply don't know. But I don't think, frankly, going back to basic propositions, there is nothing I have said which is unreasonable, that each side, fairness dictates that each side has a sense of what is going to be said. And now it's being said for the first time that there is updated information that's going to be disclosed during the session tomorrow. Now, I think it is reasonable and it's not too onerous because Mr. Wood's obviously got the information in a way that he's going to present tomorrow to you. It's not unreasonable that that is put into a form that is disclosed to both us and you, so we have a note, have a sense of what is going to be said. Because if we don't, it puts Mr. Tiley at a distinct disadvantage because he hears about this new evidence for the first time during the session. And I don't know what the consequences of that will be.
Just trying to find a plot of path through that then. We've got an issue. We've got an issue on timetable if we don't do something.
Yeah, well, we do. Well, we do and we do. Well, I mean, I have no idea I'm concerned by what Mr. Wood has said. If it was 2 sites and 2 phone conversations, that's one thing. but it's 27 pieces of new evidence that we don't know about. That is material because it changes the dynamics. Now, you had a timetable of the exchange of information, and I'm sorry, you know, I do 15 to 20 housing appeals a year, and they all proceed on the basis that it is fair and reasonable that each side know what is going to be said in evidence. That's why we have evidence and rebuttals. So I don't like the characterization that it's unreasonable of me to raise this point for the first time. I'm just emphasizing that it's reasonable that we know what's going to be said tomorrow.
Okay. The reason why I asked what level of detail do we need is to understand what it means for the numbers. So it's whether or not, and I'm thinking of what can be done to rectify the position that we're in without you working all the night effectively, but filling the gaps tomorrow. What needs to be known is what sites have there been a change, and what is the implications of that change in terms of numbers. What I'm not so sure is wholly necessary tonight is to know the reasons for that change. We do need to know them tomorrow.
We do, but in fairness, sir, we need a gateway sense. It might be, I mean, I don't want to make if I'm told that Mr. Wood's only got two pieces, as I said, two small pieces of information, then I don't want to cause a storm in the teacup. But if 27 sites, he's got updated information, because frankly, since exchange, he's made 27 phone calls and got 27 letters that aren't before this inquiry. Obviously, that's of some consequence. But if Mr. Wood has got, I'm sorry, I don't accept this proposition that we're creating this massive onerous task, because he's clearly got the information ready because he's intending to disclose it tomorrow.
What can we do, Mr. Wood, to rectify this situation we find ourselves? And I'm bearing in mind that what might be thrown into the council in terms of costs and lots of other things that could be into the equation, that I need to just have a think about to ensure that justice is being seen to be done for all parties here.
Yeah. Well,
what can we put out there?
Well, so for example, there's a site which the appellants are involved in that has been to committee since the Scott schedule was submitted, so they're fully aware of that position. That's just one example where most of what we do is in the public domain, so it's publicly accessible information. Mr. Tiley has been through our website in preparing the Scott schedule in some detail and seen all the representations that we've made on various sites and so on. It's really an update of that information between when the Scott schedule was submitted. That was the timetable that you set, understandably so. You had a cut-off date for that, and I said that the planning world doesn't stop at that date. It carries on, and there's negotiations and things go to committee, etc. In the intervening period. So it's entirely understandable and expected that things will have changed between that date and tomorrow.
That didn't answer my question. The question was, what can be done to rectify this situation?
What can be done?
What quantum are we talking about here?
What can be done, sir, is that we have the session tomorrow. We can explain the updated information that we have on site. Say
that's not answering the question that's been raised by.
I think if I finish, sir, we can provide the updated information that we have tomorrow on a site-by-site basis. If there's anything further that the appellants want to take away and explore further, we can identify those in the session tomorrow. Whether that requires a further wrap-up session, I don't know. But say we obviously do have notes of those updates, but they're not in a form to share that would be suitable to share with the appellants at this stage.
What quantum are we looking at here? Mr. White said 27. I think that was just.
Well, I think there are 57 sites, I think, that are unresolved. In terms of how many we have updates on, good question off the top of my head. I don't know, 20 odd, probably 20 odd, something like that. Some are fairly minor, just in terms of.
It's not fairly minor. It's nearly 50%. It's 40%.
Sorry, some of the updates are fairly minor. Some are substantial in the sense that, say, the example that I've given is an application that has already gone to committee post submitting the Scott schedule.
Of the ones that are substantial, how many are those?
Well, depends what you define as.
What did you use as a phrase? Substantial.
There are two that have been to committee. So on the Scott schedule, one which the appellants are involved in. There's another one which Mr. Tiley is aware of because he sent us an email, or Ms Butterfield sent us an email overnight on that particular site. So there are two that have been to committee. The others are just where Mr Tiley refers to representations that have been made on various sites in terms of objections to sites, and we can update you in terms of where we've got to with those representations from statutory consultees, for example.
So, I mean, one of the things that one has to observe about this, and it was the starting point of Mr White's remarks, is that obviously as the local planning authority, we are in a, the word was privilege, we're in a position where we have access to information which we're then able to provide to the inquiry. Much of it, as you've already heard, is purely factual information about what's happened with a consultation response if something's gone to committee, which it isn't something which the appellants can really contest because it's a purely factual matter. So this idea that they're put at some grave disadvantage by virtue of up-to-date factual information being provided, I think is rather to overstate the position. And the purpose of our contribution, certainly tomorrow, in terms of a situation where there's a full Scott schedule setting out the position on each of these sites, is simply to give those basic factual updates. And I don't think it's anything like the problem in terms of fairness that Mr White is suggesting to you, frankly.
I made a comment earlier about when looking at this evidence tomorrow about looking at the big ticket items here, rather than going through every single one in detail. So if I were to say to you, thinking about those big ticket items and where there's been a significant change that affects all big ticket items, which narrows that number down, to focus on those, could that be done as a schedule this evening? If not, I will tell you now, we may be reconvening this inquiry. Because if I've got a dispute of evidence and the manner in which that's done, and we can't resolve this tomorrow, then we're going to be sitting again. I don't want that, and you don't want that. So I'm really saying to you, can you burn some midnight oil and do something that can take us some way along this journey? If not, I'm going to get some representations tomorrow that says we need to rethink about this. The only recourse to that is to say, all right, then you're pushing the inquiry dates. And it means that we don't conclude this because we are fixed in time windows. That has implications for other things in the planning process. So I'm giving the opportunity to think, well, all right, we've got a concern. You're not going to resolve it. Absolutely, you can't. And I appreciate that. But you've already know in your mind what are the big ticket items where there's been significant change. To me, that doesn't take a lot of putting pen to paper to resolve that.
So we're happy to assist the inquiry in the best way we possibly can. So we will put together a list. It won't be a comprehensive list in the time we have available, but we'll seek to identify.
It's a significant, it has a significant effect.
So yes, we will.
That's best I can offer, I think, Mr. White. Then
obviously, can I say, both one and Fred, Mr. Wood picked up, of course, anything in the public domain, I've got no issue with, like, I'm clearly not concerned about that. Thank you, thank Mr. Wood for making that effort to help us all. Thank you for that.
I'll leave that for you to have a think about. You might want to have a chat with somebody from the appellant side, Mr. Wood, as to what it is. But yeah, I think you've been kind of given the help there that it's not things in the public domain. And I recognise there is a limit as to what you can do overnight. Yeah. But for me, it's the significant ones that have the significant effect. And if we can do that, then we're on notice.
Okay, happy to do that, sir. Thank you.
And that can be, I won't, if you I'm sure somebody, the appellant will pick that up this evening when that's sent. I probably won't get it until tomorrow morning, but that doesn't disadvantage me. I can deal with that in the morning because I'm not the one who's going to work on it.
Can I just make one observation, sir, if I may? Obviously, there will be
and I recognise the point you made.
Yeah, there will be a degree of selection of the points that we record in writing in this note. I hope that's not going to preclude us from providing other information on the minor sites, the minor points tomorrow in the way that we had intended to do.
I wasn't at all thinking that would preclude you from doing that. I think it was me saying, well, we know there are some big ticket items that, if there are some big ticket items, you need to be aware of them. And we're not going to do every 57 sites in verbatim tonight to think about as they change, It's the big ticket items, I think.
Thank
that
you,
we
sir.
just need
That's
to be
very
aware of. We're okay with that,
Yes, thank you, sir.
right? All right, and the only other thing to say tomorrow, and it's only fair that I've come across Mr. Tyler before, some time ago, by the way. I think Mr. Tucker, I think. There's points in Mr. Tyler's evidence, the points already been made that cross over with the planning evidence. So when it does cross over, I will defer to the planning evidence source. So yeah, I understand what you're saying, but I have that in the planning evidence. So it's really me saying that if you can alert him to the fact that he doesn't need to stray into things that you've already said, because that's a different forum really. So just draw back from some of that, if that was his intention, because I'll just deflect it back and say, well, actually, that's not a matter for you. That's a matter for the planning witness. And that's picking up on, I think, on your point, Mr. Callis. I think that's only fair. All right. 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 We had a good day today, a good day and a bad day. Ms. Butterfield.
Sorry, sir, I'm going back a step. On the section 106, obviously, we're looking at the matters that we've discussed today. And I've asked Mr. Callis before, but just to confirm, the council don't do DocuSign on section 106.
No, we don't. It has to be a live signature. Thank you.
No, that's fine. I just thought it was a second check.
I'm sure they get it if you paid for it. I'm only kidding. I'm only kidding. Don't go there.
Sir, my instructions are we do not sign by DocuSign in any circumstances. Thank you.
No problem. That's all right. Don't worry about it. All right. Is there anything else before I just close, and then I just need to check this link for Friday before we go probably with yourself, Mr. Callis. Is there anything else from the appellant side that I need to think about in housekeeping before tomorrow, or it's arisen from today?
The extent.
Sorry, so it is free. I'll just check. I'm pretty sure they can lock it. So I'll just double check that, but it's allocated for the duration of the inquiry.
Any further final housekeeping matters from the appellant before tomorrow? Anything from the council? In which case then it's 20 to 5. Go on, I'll let you have when it's not really appropriate.
I
one,
hope
but
you
I'll
enjoy
let
your
you.
site visit on Thursday. I can't attend on a funeral, I'm afraid, and you may get a few local residents come along, because there's been a bit of encouragement of certain parties to get people to come along to both this and possibly on Thursday. But remember, some of those who are in support of this application may not be there.
No problem, and I welcome your contribution in that respect. Thank you, understood. All right, 22:05 at that particular point, we'll adjourn and we reconvene. It's a reminder, it's 9:30 tomorrow. Back in this room, back in this same format. I'm going to have 5 minutes with Mr. Callis, nothing to do with the evidence. It's just to see if the live link works for Friday and nothing more than that. So that's what I'm doing. Enjoy your evenings. Thank you. We're adjourned at that particular point.
It's not complete, so if you leave everything with me.
That's a bit late, just going.
Yeah.
Fine.
that's not-
Do you need to log on to that link as well? I've got a link.
Planning agent, see if she wants it back.
Right. Because I don't know I'm going to see to demonstrate that there's somebody there, if you know what I mean.
Yeah.